We're live? Fantastic. Well, our third and final select committee, we are here in Cheyenne. I think it's been a productive interim. There's been a lot of work. A lot of the working groups have put in a lot of time and energy into that. And so I think my co-chair and I really appreciate all the folks who put in a lot of time, whether it's been related to our stable token, whether it is our custodial amendments. There's been a lot of work that's been done outside of these committee meetings. And so we really appreciate everybody who's put in the time and energy on this. I think it's been a pretty productive interim, and we've got a really good agenda. I certainly welcome everybody back, and thank you all who are local. We thank everyone else, of course, who's coming from afar. I like to think, of course, this is our best select committee. Ms. Co-Chair, any additional thoughts?
No, Mr. Chairman, I appreciate everybody's involvement, as you noted, and happy to get rolling on this agenda today with roll call.
Wonderful. Carissa, will you please take the roll?
Good morning, Mr. Chairman. This is roll call for the Select Committee on Blockchain for November 20th. Senator Ellis. Present. Senator Furphy.
Here.
Senator Nethercott.
Excused.
Representative Andrew. Here. Representative Singh.
Here.
Representative Yin.
Here.
Mr. Kaufman.
Here.
Mr. Pope.
Here.
Mr. Rebel.
He will be attending via Zoom.
Maybe here. Is he here?
Maybe. Is he online? Do we have him in Zoom world?
Mr. Chairman, I don't see him online just yet.
Okay, let's leave that open just in case he joins us shortly.
Co-Chairman Rothfuss.
Here.
Chairman Western.
Here.
You have a quorum, Mr. Chairman.
Outstanding. Well, first up on our agenda, we've got 24 LSO 0257, the open banking amendments. I think we've got a student from the law school. Mr. Ryan's going to be presenting this. Do you want to come forward and walk us through it, Mr. Hopkinson?
And Mr. Chairman, just a brief bit of background as they're getting organized. We have, through our Legislative Service Office, a class over at the law school on legislative drafting. And I had the opportunity to go speak to that class at one point, but one of the exercises they put forward was an opportunity for our upper division, our third-year law students, to do some legislative drafting. And so this is one of the pieces of legislation that went through that process. They're working with our staff to do the drafting work. And here's the opportunity then to walk us through the product of that work, where open banking amendments is what Connor Ryan, our 3L law student, has been working on.
Thank you, Mr. Co-Chairman. So basically, just think of this as a job interview.
No pressure.
No pressure. No, we're really excited to have you here. Love to have you walk us through this, please.
Thank you, Mr. Chairman, and thank you to the committee, the LSO, and the agency for allowing me to assist on this bill draft. This open banking bill 24 LSO-0257 was created at the request of the banking division at your last meeting. The LSO and I worked with the banking division for this new language, and the division has reviewed the bill. The proposed bill can be found in your information packets. On page 1, lines 8 through 11, section 1 indicates that the proposed amendment would amend a bill previously passed with an effective date of July 1st, 2024. The first amendment is to Wyoming Statute 13-1-801. Page 2, lines 5 through 7 provides a more narrowly defined meaning for the word customer for the purposes of open banking. For the purposes of open banking, customer is limited to only natural persons, their agents, trustees, or representatives. The second amendment is to Wyoming Statute 13-1-802. On page 2, lines 17 through 21, the amended language limits data which may be disclosed to a third-party financial service provider. Specifically, data is limited to that which is necessary for the customer to receive a product or service. Those are the substantive provisions of the proposed bill. I'm happy to answer any questions from the committee at this time. Thank you.
Thank you, Mr. Ryan. Committee members, any questions for our distinguished law student over here? Mr. Co-Chairman?
Thanks, Mr. Chairman. So I think this does two things, and we can get to the Division of Banking also for a little bit more on the details and background motivation for it. But can you tell us a little bit about the refinement of customer definitions so that we're going to natural person? It's my understanding this then would preclude having a corporation or a corporate entity eligible for the statutory provisions under open banking and the requirements therein. Is that accurate?
Yes, sir.
Mr.
Yes,
Mr. Ryan,
Chairman.
please go ahead.
Yes, Mr. Chairman.
Thank you. And can you provide a little bit of background on the motivation for that? We'll get to the commissioner as well, but if you have anything to provide for the motivation behind that change, it would be useful.
Mr. Ryan, please go ahead.
I have to defer to the agency for more of the motivation behind that, Mr. Chairman. Okay.
Mr. Hopkinson?
Mr. Chairman, I would also defer to the agency.
Perfect, thank you.
Senator Furphy, please.
Thank you, Mr. Chairman. One of the things I see happening a lot lately are living trusts. And so does that fit under the definition of natural person? Thank you, Mr. Chairman.
Mr. Ryan, please go ahead.
Once again, I'd have to defer to the agency for more explanation on that subject, Mr. Chairman.
Committee members, any further questions? Mr. Ryan? Seeing none, thank you very much. Make sure to stick around just in case we call you back up here. Mr. Hopkinson?
Mr. Chairman, just one more kind of procedural thing for the committee to keep in mind as they're discussing this bill and also the upcoming trust bill. These are bills that are in Title 13, which would generally require that they be submitted to Minerals. Minerals, to my understanding, has no further meetings this year. So if the committee does want to proceed with this bills as a committee, the statute creating the committee does not allow them to do that. So these would need to be either voted on to be individually sponsored or something of that nature.
Mr. Hopkins, that is correct. That's one of the things we'll have to consider. Mr. Co-Chairman? Or Representative Singh, please.
Thank you, Mr. Chairman. My question is, will this information be available on a third-party market data or marketplace for this information in an open forum as compared to a direct agreement between the customer and the third party?
Mr. Ryan?
Honestly, I'm not sure about that question either. I have to refer to the agency, and I don't think this bill speaks to that specifically.
Thank you, Mr. Ryan. Appreciate that. Members, any other questions?
Mr. Chairman.
Mr. Co-Chair?
Just on that point, we can have the Division of Banking comment on it as well, but the previous legislation makes sure that everything is required opt-in and pretty explicit on that opt-in. I think it would be plausible for someone to opt into the scenario that you said, as long as it was with express written agreement, and then would have the capacity to opt out. But a lot of that is going to be subject to the broader rules and regulations that the division is drafting. So I think that's another one that we can see the direction that's going. The statute would probably allow it with express opt-in, but the regulations may not.
Thank you, Mr. Co-Chair. And to tag on to that, just to kind of refresh the committee's memory, a lot of this was under the auspices, of course, what the CFPB is working on. They obviously don't move at the quickest pace, given that they are the feds. And so that was a big part of the genesis of this, was putting something in place, explicit consent, opt-in, all those kind of things. So hopefully that's a little extra background information for the committee. I'm seeing no further questions. Mr. Hopkinson, did you have any further context you wanted to provide?
No, Mr. Chairman, I think the both of you covered what I was going to bring up.
Mr. Co-Chairman?
Thank you, Mr. Ryan. Appreciate the opportunity to have you here today to present the bill to us. Great job and great work on the legislation.
Thank you all.
Let's see if we can get the banking division to come up and maybe give us a little additional little context, and then we'll move on to public comment. Mr. Bishop, obviously, we know who you are, but if you wouldn't mind to state your name and who you're with, please.
Yes, good morning. My name is Jeremiah Bishop, Banking Commissioner for the Division of Banking. Thanks for, again, having this meeting, and it's always helpful to sit in front of the committee. So yeah, just a few comments on open banking in general, also where the CFPB is, and then also then I can get into more specifics on some of these amendments. Like you mentioned, this is similar to the CFPB 1033 rule, which was passed as part of the Dodd-Frank Act back in, 2010? That directed the CFPB to establish rules on basically open banking. Where they are now is they have actually issued proposed final rules. Those came out just a few weeks ago. These proposed rules have a comment period through the end of the year. So they do take public comment on their proposed rules. The deadline for those comments are December 29th. So I've been doing my best to get familiar with those rules since they were a few weeks ago. So I can kind of go through some of the definitions that I found in those proposed rules and how they match up with the current law, and then also that might drive a little bit of the rulemaking. Just because, as I've said before, any rulemaking that I do, it's best if it's consistent with whatever the CFPB does and vice versa.
Mr. Bishop, that would be great if you would elaborate, please.
Obviously, I won't hit on every single point, but I can share some of that information, those proposed rules with anybody after this meeting. It's a long read, but.
Mr. Bishop, I know we're all busy, but it would be nice if you could circulate that just so we can get a sense of where they're at and the direction that they're heading in, please.
Yep, thank you, Mr. Chairman. I'll definitely share that 300 pages when I'm done here.
Light reading.
Yeah.
Yes.
So just some of the definitions in these rules. First is that is covered data. So that is the term that is kind of used in the actual law. So then they kind of define that further in the rule. Covered data is a transaction information, including historical transaction information in the control or possession of the data provider. Covered data includes account balances, information to initiate payment to or from a Reg E account, Regulation E account. I'll get into that a little bit later. It includes any terms and conditions, any bill information, and then any basic account verification information, but it is limited to things like name, address, email address, phone number, associated with the covered consumer financial product or service. And then that definition of covered consumer financial product or service is defined as a Regulation E account, we just call it Reg E, which is defined as a demand deposit, savings, or other consumer asset account held directly or indirectly by a financial institution and established for personal, family, or household purposes. So that's basically a basic bank account. So basic banking accounts are covered, is covered data. Any information or balances is covered data within the CFPB's rules. This covered consumer financial product or service also includes what is called a Regulation Z credit card. That's your basic credit cards. It's Reg Z covers basic credit card information. So same thing, transactions, account balances, terms and conditions. That is all considered covered data when it relates to your Reg E accounts and also your Reg Z credit cards. Then the definition of covered consumer financial product or service also just includes any facilitation of payment going from or to a Reg E or Reg Z account. So it includes the transfers in and out of those accounts as well. Another definition within the CFPB rule is that of consumer that is defined within the rule as a natural person. And it states trusts established for tax or estate planning purposes are considered natural persons. Now, this is a bit of a deviation from the actual law itself. So the proposed rule does change its definition of consumer from what was in the, we call it the CFPA, section 1002, for the CFPB is the actual Dodd-Frank Act that created the CFPB. That actual law included the definition of a consumer as an individual or an agent, trustee, or representative acting on behalf of an individual. the CFPB and their proposed rules went into this slight deviation from the law, and they said the reason for the change was to distinguish the term from the third parties that are authorized to access covered data on behalf of customers pursuant to the proposed procedures. So this is something I think that does address one of these proposed amendments today. I think the proposed amendment today is more similar to that of what was actually established in the Dodd-Frank Act law itself. I think that's still consistent. I think having those two, the proposed amendment to this bill being consistent with the actual legal definition within the CFPB, I think that'll work. I think same thing, if it becomes an issue for some reason later, again, we could do like what the CFPB did and address it in rule, or we can come back with maybe a further amendment. But I did want to go over that slight definition of a change in consumer, since that is one of the amendments, and a little bit of a background. That was one of the questions on kind of the driving force behind this inserting this definition of consumer, was mainly because the CFPB and the CFPA law included in their definition of the consumer as being an individual, not a corporation or entity.
Mr. Co-Chairman, please.
So just to clarify, we're defining in this bill draft customer because that's what we used in our statute as the equivalent to consumer, and you don't see any problem with that. So we have a slightly different term, customer instead of consumer, but that doesn't cause any problems. Is that correct?
Mr. Bishop,
Yeah,
please.
thank you, Mr. Chairman, Mr. Schroeder. I think that's correct. Seems how the Wyoming law uses the term customer throughout it. I think it's consistent to then have that definition of customer, whereas the CFPB law uses, it's just different terminology, so they're going to have a slightly different term of consumer versus customer, but I don't think it'll cause any issues.
Okay,
Mr. Co-Chair.
and Mr. Chairman, then, just for the committee's edification, and perhaps you all know this, but in Wyoming statute, we don't use the word individual in the way that we would normally expect. Individual for us includes a corporation. So in our statutory construct, natural person is the equivalent of what Dodd-Frank is using individual to imply or communicate. So this effectively, as I understand it, Mr. Bishop, is the equivalent definition in Wyoming speak to what is in Dodd-Frank and therefore will be in CFPB as the rules come forward regardless. Is that accurate?
Mr. Bishop, please.
Thank you, Mr. Chairman, Mr. Co-Chair. Yes, I believe that is accurate.
Okay.
As far as my understanding.
That's useful. Thank you.
If my Mr. Co-Chair tag on to that, has the CFPB explicitly said, we know what you mean when you use these words, they're not the exact same as ours, but from a regulatory perspective, have they been explicit about saying it doesn't give them any heartburn?
Mr. Chairman, I don't know if they've explicitly come out and said that they in the proposed rule, in the discussion document, they do include a section of, how it complies with state law. I have not fully digested that because it's not direct. But to my knowledge, I don't think they've come out and explicitly said that. So
You're a busy man, Mr. Bishop. I
that's something we
understand.
could maybe work on in the next few months.
Please proceed.
So the next area is the proposed rule is, this proposed rule from the CFPB details requirements of a third party prior to gaining or sharing access of covered data, which includes providing the consumer with an authorization disclosure. And then the rule also details minimum requirements of this disclosure. The rule provides to the third party, again, we're talking about third party gaining or sharing access of covered data. It requires that third party to provide a statement to the consumer in the authorization disclosure, certifying that the third party agrees to certain obligations, which include, this is quote, the third party will limit its collection, use, and retention of covered data to what is reasonably necessary to provide the consumer's request of product or service. So this is pretty much the second amendment that's in the bill before you today, is to make that consistent. This is something that I think I brought forward at the last meeting, that this is an important piece. Now, at that time, it wasn't, we didn't know if this would be in the rule or not. There was a discussion on it. But when a customer gives third party written consent to gain access to their information, what did they get? What information did they get? I recommended this amendment just to hone it in, like, okay, you can only get that information what's required for that product or service, rather than I'm just giving you a blanket access to everything in my, any of the financial products or services. So this is kind of, is a little bit of a consumer protection, I think. It gives the consumer a little bit more control into exactly what is covered. Now, one other difference that the CFPB rules also makes is that it establishes a maximum duration to the collection of covered data to a maximum period of 1 year after the consumer's most recent authorization. So this is something that I discussed, I think, during the last session that could be drawn out in rulemaking of, does this written consent expire? The CFPB went ahead and put that in their proposed rule that yes, it requires the consumer to give that written authorization on an annual basis. Basically, if they don't reauthorize, then the third party has to cease using that customer's data until they can get that customer to reauthorize it on an annual basis. So again, I'm not going to bring an amendment to this. I think this might be better in rulemaking, just because that one, I'd like to see where the actual CFPB's final rule comes out on this. I think there might be some discussion on this, especially when you talk about time periods, what's too short, what's too long. I think it's good to be nimble with that rather than putting it into statute.
Mr. Co-Chair, I really hate admitting it when the feds have a good idea, but I do think that that limit on data retention is a really good one. My initial reaction is I'm kind of conflicted about whether we should just amend it into the bill or leave it in rulemaking, and see what your thoughts are on that, Mr. Co-Chairman.
Mr. Chairman, I think it's worth considering that, and again, we'll have a few more months of understanding ahead of session to see how that's playing out, although we won't get, what would the potential date for a final rule be? Do we have any sense of that? Probably not at this point.
Yeah,
Mr. Bishop,
Chairman,
please.
No, I don't know. They shut off the comment period, like I said, December 29th.
Uh-huh.
Now, how long it takes to actually process those comments, publish those comments, and work it into a final rule, I don't know. I doubt it will be very quickly.
Yeah. And Mr. Chairman, I think this is one that we could potentially add. We can talk about it. It would be easy to amend in and find the right place for it. It's not a bad idea to put these types of limitations in statute that are the good bright line limitations that we want to make sure that we're providing for consumer protection.
Mr. Co-Chair, I would agree. I think that's a good point. Just given that this is a Title 13 bill, we're going to have to run this as an individual. Individually. So the good news is that we do have a little bit of time to see what additional actions develop from the CFPB. But let's kind of keep monitoring that one as we go forward. Mr. Bishop, please go ahead.
Yep, thank you, Mr. Chairman. Like I said, I'm not fully finished analyzing the CFPB's final rules, so I'm still kind of going through potential impacts it may have on Wyoming financial institutions and also how it coincides with the Wyoming law. So far, from what I could tell, these areas that I just discussed, I think are the ones I initially identified as overlapping. Obviously, the CFPB rules are much broader than what the open banking original law implies. So I think these areas that overlap, so far it sounds like it is consistent, but I still need to finish going through that and actually putting that together. Within the CFPB's rules, they do discuss how this impacts institutions under $10 billion. So again, an example, reference, the CFPB has authority over banks over $10 billion. They don't really have direct authority over banks under 10 billion. Now they have actually come out and said they've addressed this, and basically the customer interface of banks will require smaller banks under 10 billion to basically have the, I think they call it the user interface, basically capable of providing this covered data. So that's one area that I think will affect our Wyoming banks regardless of their size. Now again, our banks will have to comply with the Wyoming law anyway, so that's why I'm trying to make this consistent. Like I said, so far, I think it is somewhat consistent.
Mr. Co-Chairman, please.
And on that point, one thing we might want to do is open up the title a little bit on this bill as we work it, so that it provides some flexibility to incorporate more suggestions as this goes into the session, because I think this is our vehicle to amend the open banking and get it appropriately conformed. So rather than a narrow title, we might want a broader title.
As legislators, we're good at opening things up and really just getting all of our ideas in there. But to your point, Mr. Co-Chair, I think that's actually a good idea because if this is our chance to get those amendments, that's now is the time. Mr. Co-Chair?
So on another point, one of the areas that we thought we would be more restrictive than the CFPB, and that was intentional in the earlier draft, was on, we required effectively informed written consent, pretty high bar. Some of the discussion and even concern from some banking stakeholders was that that bar was higher than what the CFPB was probably going to be using. Can you provide some insight into what the draft rule has in place as far as level of consent?
Mr. Bishop?
Yes, thank you, Mr. Chairman. I'm just trying to pull it up, the exact language. I can't find it exactly, but they have it somewhat similar. The Wyoming law has that express written consent. The CFPB's rules have it in, as this required authorization disclosure, and then there's the certain obligations that they must get. So it's not exactly the express written consent, but it does actually require certain disclosures be made to the customer. I'm still going through it to figure out if that actually requires an actual written consent or not. But I think it is somewhat consistent as far as the disclosures and then the certain obligations are required of third parties for getting that information.
Mr. Bishop, please continue.
Mr. Chairman,
Representative Singh, please.
I have a question. So with the definition of express written consent, does that include digital signatures?
Mr. Bishop?
Yeah, thank you, Mr. Chairman. Representative Singh. It doesn't, I don't think it expressly says that in open banking. However, I think in other areas of Wyoming law, I think the express written consent does include electronic signatures. I can't remember the exact area, but I think that is included.
Mr. Co-Chair?
Mr. Chairman, our Uniform Electronic Transaction Act, UETA, and some other aspects of statute make it very clear that a digital signature, electronic signature, is legally equivalent to a written signature. So, yes.
Mr. Bishop, or follow, Representative Singh? Mr. Bishop, please continue.
Thank you. That's actually all the comments I had. Like I said, as I go through this, I might have identify some more areas as once I actually digest the CFPB's proposed rules. Like I said, I will share those. I think I'll send them to David. You can share them with the whole committee.
Perfect.
With that, stand for any other questions.
Committee members, any questions for the Banking Commission? Senator Furphy, please.
Thank you, Mr. Chairman. In reviewing all this, as a former banker, I know we had the requirements, know your customer. And that included definitely a photo ID on something that's identifiable. So when we get into these third-party financial providers, how are we going to do that so that they know their customer beyond just Social Security number and address? Thank you, Mr. Chairman.
Commissioner, please.
Thank you, Mr. Chairman, Senator Furphy. Yeah, so the Know Your Customer rule, that's part of the Bank Secrecy Act. That's every bank trust company has those requirements to know their customer. My understanding of the open banking law for Wyoming is that the customer continues to be what we're calling, well, we're at the definition of the customer, and they are just sharing their information with a third party. The third party itself, to my understanding, is not the actual customer of the bank. They don't have an account. They may not have an account at the bank, and so the bank isn't required to know who that third party is. Since it has that express written consent from the consumer or the customer, I think is then on the customer to decide, do I want to share my information with this third party? It does not put any of the burden on the bank to verify who that third party is. If you get that express written consent from the customer, you will share that information with this third party as directed by the customer. But since that third party may not be a customer, they may not know much information, and I don't think they would be required to know under banks, the BSA requirements to actually identify who that third party is and who's behind it. Similar to they would have to if that third party was a customer. So I don't think that really applies. I think that goes on the what we're calling the individual the burden is on them to find out who they're sharing their information with.
Senator Furphy, follow-up? Excellent. Mr. Ravel, I see you're online. Did you have any questions or comments? I didn't get a chance to acknowledge you earlier.
Thank you, Mr. Chairman. No questions or comments at this time.
Excellent. Well, seeing no further questions from the committee, let's go ahead and open up to public testimony. Does anybody online or in the audience have any, let's start in the audience, any testimony or questions on this specific topic? Not seeing any. I don't think we've got, do we have anybody on Zoom World? I'm not seeing any.
I was expecting Scott, but he should have said no.
So seeing no, Mr. Meyer going once, going twice? All right, so public testimony is closed. Mr. Co-Chairman, kind of circling back in our previous conversation, obviously because this is a Title 13 bill, which has to go through our Minerals Committee, we can thank the former chair of Minerals from the Bighorn Basin for requiring that. But it does present that question of, we can't go through there, so really our options are to individually carry this bill. And I'm certainly inclined to do that, and we can work with our committee members to do that. But Mr. Co-Chair, please, what are you thinking?
Yeah, Mr. Chairman, I think it would be worthwhile to just work the bill as if we were going to pass it and then effectively table it from there. Just see if there's any amendments or any suggestions and have that discussion. And then not take final action on it since we don't have the authority to sponsor it based on statute. And then a follow-up working with committee members to figure out how we want to have that bill sponsorship, who wants to prime sponsor it. And then my hope is that we'll all effectively sign on if everyone's comfortable with it and do our best to treat it as a committee bill, even if former Minerals Chairman has precluded us from doing that.
Precisely. And Mr. Co-Chair, I think that's a really good point. You know, we want to give the bill the respect it deserves, so we should work it. Let's go ahead and start on page 1. It's really just kind of the enabling language. So really the first major component is there on page 2, on line 5 through 7. I think this certainly makes sense. I have no issues with it. Mr. Co-Chair, do you have any heartburn or concerns? Good. So let's just kind of keep working through lines 9 through 20.
Representative Singh.
Representative Singh, please go ahead.
Sure, thank you, Mr. Chairman. What would be the implications of adding the word corporation after agent? So inserting agent and then or inserting corporation and then comma. What would be the implications of that?
Well, Representative, I certainly think that part of the intent was some of these institutions deal with these trusts, whether they're irrevocable or otherwise, and including that, making sure that they have access, that this can, that they're covered by this, that these financial institutions, these APIs can engage on these specific types of customers. Mr. Co-Chair, do you have any thoughts?
Yeah, Mr. Chairman, I think with Dodd-Frank coming up with their consumer and trying to structure it that way, if we provide what are effectively the Dodd-Frank consumer protections or will be to corporations, you've got an interesting circumstance where corporations are already doing business-to-business agreements typically and can buy services or not. And you also have kind of a difference in how you would handle consumer protection in those types of circumstances, or the need to handle consumer protection in those circumstances. I think it could possibly be done, but I think it might also be awkward and not well thought through. I guess I would say I don't really know exactly what would happen if we extended the same coverages and protections and requirements to corporations in this instance as we did to natural persons. I think natural persons were the intent of it from a consumer standpoint. We could pull back up Mr. Bishop and see if he has any.
Yeah, Mr. Co-Chair, I would largely agree. I mean, I think the whole purpose of this bill last year was to explicitly enable, put a flag in the ground towards these new types of these banks, these speedy banks, and to send the message and plant the flag that these new types of banks and the vendors they work with, these really sophisticated APIs, specifically for those individual users or those small types of entities, whether it be a specific person or, you know, a authorized agent thereof or these trusts. But I would be curious to get the commissioner's opinion on this and see if you would opine and weigh in. Mr. Bishop, please.
Yes, thank you, Mr. Chairman. So just to understand, it's contemplating whether or not corporations should be included within the definition of customer. Historically, I think when we had been, during the last session, when we were talking about open banking, the discussions were always around individual consumers, natural persons. The CFPB rules are definitely towards persons, mainly because it's the Consumer Financial Protection Bureau. They concern themselves with consumer protection. So I think this bill, similar to the actual law that was passed last year, was more towards individuals because it was a consumer protection bill. It is making sure that individual natural persons are protected from corporations sharing their information. That was one of the main points of this bill. In most cases, corporations don't receive that same type of protection, mainly because they're corporations. It is assumed that they are responsible for their own information and that they are capable of getting contracts, things like that, and actually knowing what they're doing a little bit more than natural persons. So I think that's one of the reasons for this difference, is more consumer protection applying to that consumers, not so much as corporations. Now, if you were to include corporations into this, I think it would just put those same requirements on banks on whether or not it's an individual or corporate customer. I don't know what the end result of that is. It extends those protections to a corporate. Now, I think since the CFPB has come out with their proposed final rule, there has been some discussion on, well, what about maybe small businesses? They would like to have some of this as well. Well, they currently can. They're allowed to do this currently. Actually, even natural persons are allowed to do this. There's nothing prohibiting them from doing this at all. So I think it's just depend on whether or not you want to add these same protections, having that same express written consent from a corporate customer as you would for an individual. I'm not sure what that answer is, but that's the question, is whether or not you want to extend those protections or not.
Mr. Chairman?
Mr. Co-Chair, please.
I think it's important to emphasize that concept that nothing is prohibiting an open banking program from engaging a corporation. It's just, do we put in place the same level of consumer protection? For a small business account, that's an interesting discussion, where a small business is probably going to be, you know, one or two people with the account in a lot of cases, or you've got that type of circumstance throughout the state. That would be worth more discussion and understanding. It'd be hard to carve that out, but it's an interesting discussion point. It sounds like that's happening with the CFPB discussion as well. How do we provide protections for those small businesses?
Mr. Bishop,
Mr.
please.
Chairman, yes, Senator Rothfuss. Yeah, I think that was more of a, maybe not at the CFPB discussions, but third-party discussions saying, hey, small businesses do the same activity. They'd like to allow for the same open banking concept. But yes, to your point, they currently can. They're allowed to. There's nothing prohibiting businesses from doing that today. It's just, do you want those protections in place for them? How do you go about that? I don't know. And then again, the CFPB only, like I said, that would deviate from what the CFPB is doing with open banking, or their open banking rules only applying to individuals, not small businesses. I'm not sure if that's really in their scope. So,
Mr. Co-Chair, or Senator Furphy, please.
Thank you, Mr. Chairman. Well, as the commissioner knows, at the federal level, I'm not talking state banking, but national banks, the consumer protection laws are separated from the corporation laws. Corporations, even small businesses, are not protected under the consumer protection laws. So I just wanted to point that out, Mr. Chairman. Thank you.
Thank you, Senator Furphy. I think that's a valid point. And when I look at these types of new ideas, I always kind of reference it back to what was our original intent with the legislation in the first place. And does a suggested amendment or idea, is it congruent with that? Is it complementary? Does it conflict, or does it muddy the waters? And I guess to the commissioner's point, a lot of these larger corporations, they're sophisticated and capable organizations. They have attorneys to sort through this kind of stuff. So I'm not really worried about them. I think the only case that would give me pause or worth consideration is if I'm a business with 3 employees, I deal in digital assets, and I want my Speedy Bank to be able to engage and make sure I'm covered if I want to engage in these types of relationships with these APIs and the banks and their vendors. Mr. Co-Chairman, what do you think?
Well, yeah, I'm thinking of those small individuals that, like, under any circumstance, just imagine that you've got a, 2-person coffee shop or whatever, right? That owned by 2 individuals, small business. With no protections on open banking, they may have an expectation of protections. That a lot of their personally identifiable information would probably be involved with the opening of those accounts. If they sought additional services through that small business, I'm just wondering whether that would be a kind of a nice little loophole to then take information about those individuals that are the account holders and have boundless sharing, where there's an expectation of consumer protection, so they think they're consumers at that point. I agree with you that, if you've got a large C Corp with accountants and plenty of people supporting it, we probably don't have, like, if you've hired Mr. Pope over there, then yeah, we'll single you out. Then hopefully you're okay. But I don't think there would necessarily be an understanding that because you've opted to have a corporation or an LLC or some corporate structure, that you've waived all of your consumer protections and your information can be freely shared. I guess that's worth discussing, and ask Mr. Kaufman if he has any thoughts on that, because I don't, he has a lot of experience with maybe smaller businesses, setting them up and how their structure works. How would bankers engage with this, and should we be protecting those people?
Mr. Kaufman, what are your thoughts?
Yeah, thank you, Mr. Chairman. I don't know that I have any, real specific thoughts to share. Just kind of coming back to the discussion at large, my understanding of this is, like those data aggregators and services that people use, right? I mean, that's really what we're getting at. And a lot of that market is retail driven, not, business driven. At least I think that's my understanding of the products and services bills like this are really trying to get at. So, I tend to agree with the commissioner on this. I think keeping it tailored towards the consumer protection in the individual for this context makes the most sense to me. Just, it's a permissive bill, right? And we're just simply putting guardrails on it. So I don't know, that's my perspective.
Mr. Singh, let's bring it back to you. You still feeling the same way, or elaborate on what you're thinking?
Thank you, Mr. Chairman. I think the conversation warrants more conversation. Yeah, there are more aspects to this that I would have to think about in order to include that in the definition.
My thought is maybe let's just leave it out for now. Again, we have plenty of time between now and February 12th. Mr. Co-Chair, what are your thoughts?
Mr. Chairman, the first approach we had with the bill was we gave it a couple of years to get it ready anyway, so that delayed effective date, I think, was an important one for this. We can implement on that July 1st, 2024 timeline for the individual consumer protection, or what we think of individual natural person consumer protection. And then we can really start contemplating and see how things could play out if we wanted to extend those protections to certain business classes. Maybe that does make sense. Maybe it doesn't, but I don't feel like I know enough, or we've thought about it enough to pull the trigger on that at this point.
With that being said, let's continue. Mr. Pope, please.
There we go. Thank you very much. I just want to say I think it does bear further discussion, because most of the clients that I have are within the category of 5 or fewer owners, and almost all of them have entities that would be the interface between them and the banking world. So I believe further protections are warranted, but I think we can, of course, just look at that down the road.
With that being said, let's continue on through the bill. Let's move to paragraph B, lines 11 through 21. Are there any other thoughts, or I think it looks pretty good. I think the one,
Go ahead.
well, just that idea of explicitly outlining retention limits, putting in 1 year. I think that's probably a pretty sound idea. I guess the question is, do we allow the agency to do it in rule, or do we want to put it in the bill? As a legislator, I would prefer to have explicit language in there, but Mr. Co-Chairman, I'd be interested in getting your thoughts on this.
I think coming up with those retention limits for this legislation is probably a good idea, but I wouldn't want to just cobble something on to the end of it for not less than 1 year or something along those lines, because I think we should first look at how it's being put forward in the proposed rules and try to see what they're contemplating, whether there's exceptions, whether there's specific requirements, data retention policies, or anything along those lines, which are potentially a good part of it as well. So I'd probably hold off for now, but that would be a good amendment for us to work on for session and try and bring that in one of the standing committees to figure out what those the data retention and look back policies are.
Senator Ellis?
Thank you, Mr. Chairman. Just a thought too is the way the other sentence is worded, I'll talk about the participating bank's duties. And so this is just kind of worded in the passive voice. If you wanted to make it a little more clear that it's the participating bank's duty, you could say it's the participating bank shall limit the accessible customer data to that which is necessary for the customer to receive a product or service from the third-party provider. Just a thought is, if we're bringing it as an individual bill, it's a new statute, so I think it's good to make them clear at the outset.
Our in-house grammar police is on it. With that, we've got the effective date of July 21 or July 1st, 2024. Ms. Co-Chair?
Yeah, Mr. Chairman, I think we should substitute the language for Senator Ellis's suggestion. I like the shall limit. So Senator Ellis, can you read us through how you structured that on page 17?
Thank you, Mr. Chairman. The participating bank shall limit the accessible customer data to that which is necessary for the customer to receive a product or service from the third-party provider. All the same language, is kind of in a different order. And then if you structure it that way, then you could say the participating bank shall limit, and then add your 1 year, just to keep that flow going.
Mr. Hopkinson, did you get that?
Mr. Chairman, I got most of it, but if you wouldn't mind one more quick run through and I can,
Yeah, Mr. Chairman, I can just walk it over there to you if you want to.
Okay,
that works fine.
let's do that.
Do that, yeah. Mr. Chairman,
Mr. Co-Chair?
if everyone else is comfortable with it, I'd prefer to use Senator Ellis's structure, because I agree that if we wanted to add additional sentences afterwards, it also makes it easier to maintain that construction. And whether it's the participating bank or a participating bank, either way, having that have a shall clause, I think works well.
Makes sense. Any committee members have any heartburn over that one? I think we'll just opt to not do a voice vote, just because it's,
Yeah,
we're just kind of informally working it, because we'll motion to table it. Any further comment from the committee on the bill?
Is everyone, Mr. Chairman, I guess I'd ask this, since
Co-Chair,
we're not going
please.
to have a vote on it, is everyone comfortable with this bill? Are there any concerns that we haven't talked about or identified, or are we in good shape going forward?
Is the committee, is following up Mr. Co-Chair's comments, is everyone okay, at least considering co-signing onto this one during session? I'm not sensing any major heartburn.
All right.
Well, I think with that, we'll do a
We can just let it hang.
Yeah,
We
we'll
don't even
just-
need a motion.
motion, we'll just table it.
Yeah. Without a
but we don't need a voice vote unless there's an objection, which I don't sense. Moving on to our next topic, 24 LSO 10102, just banking assets and bankruptcy clarification. Mr. Hopkinson, I think we've also got. This is kind of a big one.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, working through 24 LSO 0257. Mr. Chairman, this bill draft arises out of some earlier discussions in previous meetings about, excuse me, I grabbed the wrong bill draft. If you'll give me just one moment.
Please go ahead. And I'll maybe fill in while Mr. Hopkinson's getting the right draft. This came from the discussion of federal bankruptcy proceedings and how there was some concern around the clarity about the relationship between some of these trusts, their assets, and the vendors, the third parties that they deal with, whether it's a credit debtor status, those kind of situations. And so as it dealt with some of these digital assets, providing more clarity in how that they are to be held, by who and what responsibilities they have was something that we had worked on. We'd had at least 3 or 4 working group meetings. So we put quite a bit of time into this. I know Chris Land from Senator Lemus's office has put a bunch of time. There's been some other folks who've really helped out along the way. I think one of the big things, of course, was establishing that there was that clear, defined relationship between these trusts and having a trust instrument that governs the relationship between these third parties. So with that, Mr. Hopkinson, please go ahead.
Thank you, Mr. Chairman. Walking through 24 LSO 102, working draft version 6, trusts and bank assets and bankruptcy clarification. This bill draft, first thing it does is create a new Article 13.1.206. We see that new language is provided on the next few pages. First up, in subsection A, provides that custodial or fiduciary accounts, and I want to pause there just a moment because that term or those terms is actually defined on pages 6 and 7. So a custodial account on page 6, section F1, is an account that's established by a financial institution that does not involve the exercise of substantial discretion and involves the safekeeping, servicing, and management of customer financial assets. And a fiduciary account is an account governed by Title IV and is established by the financial institution for which the institution owes a fiduciary duty to a customer, and that involves the exercise of substantial discretion, including investment advice or investment decision-making related decisions to financial assets. So with those definitions in mind, going back then to page 2, subsection A, provides that those accounts, a custodial or a fiduciary account, under the management or administration of that financial institution that meets the requirements of subsection B, which we will get to shortly, that the account shall not be deemed assets or liabilities of the financial institution for the purposes of receivership, conservatorship, bankruptcy, etc., under state or federal law. And it requires that those accounts be maintained off balance sheet for accounting purposes, and provides that this new section and any other applicable provision of Title 4, 13, and 34 shall govern whether an account is a custodial or fiduciary account for purposes of those bankruptcy type proceedings in Title 7, 11, 12, or 15 of the United States Code, or similar proceedings under state law. Subsection B on page 2 provides that essentially that a custodial or fiduciary account is subject to these following requirements. Paragraph 1, that it shall be governed by a properly documented agreement with a clear legal relationship between the financial institution and the customer. Provides in paragraph 2 that the assets in the account shall be properly identified and segregated with proper documentation of segregation evident on the books. Paragraph 3, that the digital assets may be held in omnibus digital wallets with other customer digital assets, provided that they are segregated on the books. Paragraph 4 provides that the assets of the financial institution shall not be commingled with customer assets. Paragraph 5 on page 6 or page 4 provides that digital assets in a covered account may be staked on third-party protocols, but only if they meet these following requirements. The agreement specifically authorizes staking. The agreement requires the return of staked digital assets directly from the third-party protocol to an account holding only digital customer assets, and that the agreement otherwise complies with Wyoming Statute 3429-104, which is our digital asset custodian statute, which we'll see some of here in a few more pages. Paragraph 5 is similar, paragraph 6 is similar to paragraph 5, which deals with paragraph 5 dealing with the digital assets in a covered account, allowing for staking. Paragraph 6 allows for that they may be traded on third-party platforms with similar requirements to the staking protocols, with one additional requirement in subsection B that provides that the digital assets may not be held on third-party platforms for a period of time longer than reasonably required to execute the transaction. Moving then, page 5, paragraph 7 is a bit of a catch-all. The custodial or fiduciary account meets all other applicable requirements of law, including Title IV and the various digital asset and property statutes. Subsection C provides that as determined by the Commissioner of Banking, that a deposit held by a depository institution in reserve with respect to virtual currency shall not be subject to this section. And while it's worded pretty broadly, that essentially applies to the stable token. Subsection D provides that all custodial and fiduciary account agreements shall cite this notice. So it requires a notice to be included in all agreements, custodial or fiduciary agreements. On page 6, that notice at the top of page 6 just provides that the account is entered into pursuant to the new statute that's created, 13-1-206, that all parties intend to create an account in which all assets provided pursuant to the agreement remain the property of the customer and not the financial institution. And the financial institution agrees to comply with this new statute and refrain from commingling any customer assets with the assets of the financial institution. Subsection E provides that nothing in the section should be construed as restricting or prohibiting the use of a sub-custodian when they comply with the requirements of the section. Subsection F is just the definitions that we already looked at. Then on page 7, it goes into the supervised trust statutes, 13.5.417 in subsection F. And we see some new language there in 22 and 23 that provides, and what this section does is if the commissioner determines it's in the best interest of both the state and the supervised trust company, that they may require the supervised trust to file a petition under Title 11, the bankruptcy statute. And the new language just provides that if the commissioner has been appointed a receiver under this section prior to filing that petition, that they shall be discharged from any further duties after the commencement of that bankruptcy proceeding. Next, on page 8, we go into the digital asset custodial services statute in 3429-104. And the first change we'll see here is it tweaking the language to kind of match some of those new definitions that we saw previously, where we get that a bank may provide custodial or fiduciary services on line 8, line 9, for digital assets, consistent with the section upon providing that 60 days written notice to the commissioner. We're striking the language that's in statute on lines 11 through 13 and adding on 14 custodial or fiduciary services for digital assets on line 15, and then providing a kind of an inclusionary term for custodial services, and it provides that the term custodial services shall include fiduciary services in this section unless the context requires otherwise. It's as determined by the commissioner. In subsection C, striking the language depository on line 21, where we're talking about digital assets held in custody, they are not changing that from depository liabilities to just liabilities or assets of the bank. And then on page 9, we're creating a new subsection P that provides a trust company shall comply with the provisions of this section if it provides custodial or fiduciary services for digital assets. And then we strike some language on the bottom of page 9 in custodial services, changing that definition slightly, with the new language being on page 10. And that new definition of custodial services would mean the safekeeping, servicing, and management of financial assets that does not involve the exercise of substantial discretion. And then a new definition for fiduciary services being an account established by that financial institution and for which the financial institution owes a fiduciary duty to a customer. So similar to those definitions that we've seen in the new section. With that, Mr. Chairman, I'd stand for any questions on this bill.
Thank you, Mr. Hopkinson. Before I open up to questions from the community, I guess an additional component of context is I think we always ask, why is this here? And the reality is that with these digital assets, there have been concerns when some of these, in the case of bankruptcy, who owns these digital assets? On whose balance sheets do these assets belong? Can they be considered as part of the estate by some of these bankruptcy judges? And I'm sure Mr. Evans, Mr. Revelle will provide more context, but that's the basic question that we're trying to answer here. And I'd like to think the good co-chair and I are very pro-property rights. We want to make sure that we have language on the books that enables and protects your rights, your property, to ensure that these are your assets and that they can't be severed from you or your estate. And so I think we've got a good, solid pro-property rights bill in front of us. So that's just some additional context, I think, for some of our newer committee members. So with that, I'm going to open up to the committee if there are any questions for Mr. Hopkinson. Representative Singh, please go ahead.
Thank you, Mr. Chairman. Mr. Hopkinson, can you define what an omnibus digital wallet is, and is that associated specifically with a single computer device?
Mr. Hopkinson, do you want to take a stab at that?
Thank you, Mr. Chairman. That term, I believe, came out of the working group. I would defer either to Mr. Land or Mr. Revelle on the specifics for that term or the need for that specific term, but that was part of the working group discussion.
So, Representative Singh, part of that is that some of these custodians, some of these institutions were using these types of vehicles, and so that's why that language is included. At a broad level, that's the short answer. I'm sure maybe Mr. Evans or Mr. Revelle wants to jump in, or Mr. Lamb, but that's at a high level why that language is in there. Mr. Co-Chair, do you want to jump in?
And we can get Mr. Land or Mr. Revelle on, but the omnibus wallet, if you are possessing digital assets on behalf of customers or third parties, and imagine that you are an exchange or something along those lines, and rather than assigning specific wallet addresses for each, you have a large number of one particular cryptocurrency, will say, that you've assigned internally through your accounting ownership to all of the clients, but you're holding in a common fund. That's going to be the omnibus wallet, so you can transact without having to have the additional signatories on their behalf, or you're using them as either co-signatories so that they're executing the transaction. But effectively, they are being held by the same wallet, but being accounted for separately on behalf of those asset holders. And maybe Mr. Revelle can provide a little more clarity.
Mr. Vell, do you want to hop in and comment on?
Yeah, thank you, Mr. Chairman. I think Co-Chairman Rothfuss did a good job of explaining it in concept. I might ask if Joe Evans, who is on the line and is part of our working group from McDermott, Will, and Emery, might want to add to that in terms of how a bankruptcy judge might view specifically an omnibus wallet.
Mr. Evans,
Sure.
please go ahead.
Thank you. Joseph Evans from McDermott, Will and Emery. So what this is describing here is an omnibus digital wallet, which means that customer crypto will be commingled with other customer crypto. It's an important distinction. We're not saying that customer crypto will be commingled with company cryptocurrency. Those would be completely segregated. The reason why omnibus digital wallets are often used is because the service providers that a trust company, a bank, that others would use to store customer digital addresses often, if not exclusively, require that you have a customer omnibus digital wallet, then you have a company omnibus digital wallet. And so the questions that have been raised by bankruptcy courts across the nation that we've been involved in is, well, is there commingling between customer crypto and company crypto? That's a much different question than customer versus customer. And so what we tried to capture here is a reality of storage of digital assets where customer assets are commingled with one another, but not with company assets. And as to your second question as to whether it's stored on a particular computer, when we talk about storage, what we're really talking about is access. So who has access to the digital wallets? Because really everything is stored on the blockchain. And then the question is, which entities have access to the digital wallet? And that will be determined by whoever has what are called the keys or the private keys to facilitate transactions into or out of an omnibus digital wallet. And so one reason why we included this in this proposed bill is if, for example, we required that every trust company, every Speedy, every bank that wanted to have bankruptcy protected customer crypto in segregated wallets, for example, we believe that that would be overly costly and not really workable for any of the custodians that are currently providing these sorts of activities. There are distinct situations where you might have a segregated wallet, but as the business has grown and as the custodians become more strict, this is the reality of the situation and ones that it appears that bankruptcy courts are protecting as long as the company and the customer assets are segregated.
Representative Singh, did I answer your question?
Thank you, Mr. Chairman, and Mr. Evans, that answered my question. My concern was whether or not if the device itself was destroyed, would you lose the asset? And so I think you answered my question.
Excellent. Well, that, Mr. Co-Chair, please.
Thank you, Mr. Chairman. So one question I have about the construction for the working group on page 8, lines 16 through 18. The term custodial services shall include fiduciary services in this section unless the context otherwise requires it, as determined by the commissioner. It's my understanding that the intent of that is largely from the statutory construct standpoint of not having to go back in all the places where custodial services is written throughout this section and make it an or fiduciary services. That's my expectation of that. That's intended for simplicity. The concern I have is the plain reading concern, where we very explicitly in the Q section and appropriately lay out the differences between custodial services and fiduciary services. Most of this section applies to both fiduciary and custodial services, but there are some differences, and I'd just like to hear from the working group kind of the conversation about that. It almost seems to me that for clarity, we might need to go back in and call out custodial or fiduciary services time and again, and then strike this language about on page 8, 16 through 18, because I'm afraid there'll be plain language confusion by folks that are reading it and thinking custodial services or fiduciary services when it's not explicitly laid out whether both or only one applies. So a little thoughts on that. It's my assumption that's the intent, but.
Mr. Evans, would you mind jumping in, or Mr. Ravel? Which one? Are you?
Yeah, I'll jump in if I could, Mr. Chairman, and then I'll ask
Please.
Mr. Evans to chime in if you would like. You've arrived at a point that still needs a little bit more work. Co-Chairman Rothfuss, there is some tension in the way that the working group views that this ought to be drafted. And let me just start first by the overriding intention of this is to give clear direction to a bankruptcy judge on how a specific account should be treated in the event of receivership or failure of the institution. And in doing so, the kind of optimal structure would be that there is simply one account type that we define, and that could be viewed as a custodial account. The institution could then have different types of accounts, but all where there is varying degrees of discretion over the assets by the institution, which comes with varying degrees of liability, etc. But all accounts are a custodial account and therefore viewed as off balance sheet for purposes of the bankruptcy court's interpretation. The problem is, do we create confusion by narrowing it down to just one account when in reality there will be different relationships that exist between the financial institution and the client? And that is where the working group is right now in trying to decide the best way for us to define the account or accounts and the best language to use. The reality is that the working group would like a little bit more time to work on how to define this exactly. In concept, I think we are where we need to be, but the kind of whether it's one definition or multiple definitions and what provides the most clarity to a court is what we need to iron out.
Thank you, Mr. Ravel. Mr. Evans, did you want to jump in there?
I did not. Mr. Ravel did a great job. Thanks.
So my thought was, given how this is another Title 13 bill, that we will have some extra time to convene the working group and allow them to continue to work out some of the kinks to come up with a more clear language. So we've got a couple of months. Mr. Co-Chair, please.
Yep, Mr. Chairman, agreed. And I think that tension is one that we probably need to come up with a more elegant and clear solution. The question I guess I have in clarifying here, it's not necessarily structured this way in the definitions, but if you have a custodial account concept or custodial services, I guess I would ask if it's always true that fiduciary services would be a custodial service with fiduciary responsibility. So it's an additional, we'll say, feature. I think that's the case, and if so, maybe that's the appropriate construct, is to make it clear that they're not mutually exclusive, which the definition kind of makes them seem like they are, because custodial services is defined as not involving the exercise, where fiduciary services does involve the exercise of responsibility. Maybe we can change that so that it's a subset of, and at that point you can strike that language and just use custodial services where custodial services applies, and then the special note of fiduciary services as a subset of custodial services becomes a key term of art that's used when it applies, and that might provide the bright line clarity that I think we'll need. I think if this, as structured, if it hits the legislature and somebody takes sufficient time, as they should, to read page 8, lines 16 through 18. It's not going to go well. So I think we need a different solution there.
So, Mr. Co-Chair, just for some clarification, the concern is that the fiduciary services can be included in the custodial services component, but not the other way around. And having better delineation, I think, would be good for anything being interpreted by a bankruptcy judge. Am I understanding that correctly?
Yeah, I think so. Assuming that that's true, and that is my question, and I think it's true that, if you were to draw your little Venn diagram, you'd have a big circle of custodial services, and then within that, you'd have a small circle of fiduciary services that's entirely within custodial services. I think that's an accurate statement, but I don't know that. So I guess I'd ask Mr. Evans and Mr. Reville if that's always true or if there are exceptions.
Mr. Co-Chair, I like Venn diagrams personally, but Mr. Revelle, please.
Yeah, thank you, Mr. Co-Chairman. That was an accurate description, and whether that is the clearest way for us to define it for interpretation by a federal bankruptcy court is where the debate still continues amongst the working group. But you have the concept generally correct. Every account would be a custodial account, if that's the word we end up on. I'm not quite sure yet, but an off-balance sheet account. And then there could be varying degrees of discretion or fiduciary activity that are built upon that.
Mr. Evans, did you want to jump in?
No, again, that was just right.
So, Mr. Co-Chair, kind of my thought would be, if you look at how well they've delineated all this stuff on how it's to be accounted for on the balance sheet perspective in 206, for this to qualify for that, these circumstances much apply. Is there anything preventing us from doing a similar thing to try to hammer out that confusion that you're talking about on page 8? Where we say, okay, for this to qualify as this as well, it needs to meet these types of conditions and circumstances.
Yeah, Mr. Chairman,
Mr. Co-Chair.
I think so, and it sounds like the working group is onto it, but just hadn't kind of arrived at that final language yet. So if we, allow another iteration before we get this bill finalized and sponsored, introduced, hopefully we can get that clarified. That's the only challenging ambiguity I've seen, and I think this is important for us to work this one out very well. This will end up being one of those guidance pieces of legislation, I believe, that other states are going to copy and paste what we did, because we're at the forefront on this. It's a critical legal concept, even if it's not a sexy legal concept that a lot of people are talking about. It's pretty important. So we should get this right. We should get the language right, and make sure that we get it across the finish line so that this bright line clarity for digital asset custody in bankruptcy is apparent. And we've seen, obviously, over the past few years, circumstances where that bright line clarity would have been handy and wasn't there. So,
Mr. Co-Chair, I wholeheartedly agree. Per usual, we're trendsetters here in Wyoming. Very proud of that. Mr. Evans, Mr. Revelle, from a timing perspective, again, this doesn't necessarily have to be ready for prime time until February, because it's a Title 13 bill, which means that it has to go through the Minerals Committee, which they are not scheduled to have any more meetings. So is there enough time between now and then, do you think, for the working group to reconvene and continue working on this definition or on this language? I'm seeing head nods. Excellent.
Yes, Mr. Chairman, there is. Thank you.
one more
Yes,
question.
Mr. Chairman.
Mr. Co-Chair, please.
And with regard to that, so that's the only concern I have that with the language and with the way things are structured. I think, again, we'll walk through it, but are there any other features or aspects of this bill that are still under discussion? Are there any other features that need to be added? What's the conversation in the working group on that?
Mr. Revelle?
Yes, thank you, Mr. Chairman. There's some minor fine tuning And then there is one other concept that is still under discussion, which is the treatment of stablecoin or stable token in the case of the Wyoming issued stablecoin reserves and how those are treated. And again, there's a little bit of a debate here that gets down into some fairly technical weeds, but that would be the other issue that's probably worth pointing out, that you may see some language change.
Great, thank you.
Mr. Revelle, one thing that I have a question that came to mind is that substantial discretion is used throughout the bill numerous times. And I mean, how do we define that in relation to the issue that we were just talking about, making sure there's clear delineation between custodial services, fiduciary services, et cetera? Because I think when I think substantial discretion, I think we're getting into the realm of that fiduciary services, because you are fiduciary, you're using your substantial discretion, best discretion, however you want to refine it. So could you touch on that, please?
Yes, you're right. So there should be a delineation, or the financial institution should be allowed to distinguish or delineate between services where they're providing a passive or directive role as just a custodian, and a role where there is discretion or substantial discretion, where it's more of a fiduciary role. The tension there is that it may create some confusion, or sort of runs counter to the whole purpose for this clarifying bill in the first place. And if I might ask Mr. Evans to expand a little bit more on that, but where the tension lies in creating the clarification for a federal bankruptcy court.
Mr. Evans, please go ahead.
Yeah, the substantial discretion question is really one as to whether it's a fiduciary versus a non-fiduciary account. That distinction is not one that is necessarily drawn by bankruptcy judges as to whether the account is what I would refer to as bankruptcy remote or bankruptcy protected or not. The bankruptcy protected question is going to turn on whether the assets are segregated and were always intended to be held what is called in trust. And so that's really the key distinction to be drawn here.
Thank you, Mr. Evans. Committee members, before we bring up state agencies, any questions or concerns? Mr. Kaufman, none? Mr. Bishop, would you mind coming forward and opining on this one for us? As the executor of these potential bankruptcies before they go into Chapter 11.
Yes, thank you, Mr. Chairman, Mr. Co-Chairman, and committee. Yes, generally, I think this bill, there's a lot I like about it. I like that I like that we are making it clear, very clear, that these types of assets are not assets of the company, and at no time ever will be considered assets of the company. I think that is very important to draw that distinguish that in all cases, especially for bankruptcy, like Mr. Evans was saying. That has caused some issues, I think, during the bankruptcies that happened last year, is what are these assets of the customer, or if you have an account at some of these entities, are you basically an unsecured creditor? I think this bill definitely addresses that very big problem. I also like the split, I guess, between custodial services and fiduciary services. This is something that we deal with consistently, of whether or not you have fiduciary duty. Just because if you are a fiduciary, you do have, not everyone can be a fiduciary. For example, if you offer a trust business, you have to have trust powers. So this draws that, distinguishes those as well. Now, going back, before I get into some of my comments on the discussion that just happened, the difference between custodial services and then fiduciary services, yeah, I would say those are very different things. Custodial services, you're holding, you're not managing. Fiduciary, you have a much higher standard of care. You owe that fiduciary duty to your customer, and so I think those are very different concepts. And so, Co-Chairman Senator Rothfuss, and you said your understanding, and I think it was page 8 16 through 18. That was my understanding as well, was that these should be included. But we need to go through the entirety of 3429-104 and make that change. I think that'd be up for the working group, but my understanding was that was the intent of this section, was to basically make that a blanket throughout that entire section statement that anywhere that it says custodial services, that includes fiduciary services.
Mr. Co-Chair, please.
Just on that point, and not that this is perfect language, but getting back to the kind of the Venn diagram concept, if we go into the definitions and say something along the lines of, and it doesn't have to be the word custodial services, but trying to get to the point where it's clear that a fiduciary service is perhaps a custodial service with fiduciary responsibility, something along those lines, and then laying out what that means. At that point, this passage is obviated and the rest, everything else becomes true again, because wherever it refers to custodial services, it refers to the broad category. And then only when you're specifically referring to fiduciary services does it narrow down or need to narrow down to fiduciary services, since one is a subset of the other. Does that make sense as a first step, or do we need to be more subtle than that?
Mr. Bishop.
Yes, thank you, Mr. Chairman. Yeah, I'm not sure the best way forward with that, just because if you're doing a fiduciary activity, you're no longer just a custodian. You are now a fiduciary, so that Venn diagram doesn't actually really overlap. If you're a custodian, you may not be allowed to be a fiduciary. Whereas if you are a fiduciary, you're doing way more than just a custodial work. So that Venn diagram, they actually don't really meet a lot of times. You can be a custodian as a fiduciary. You cannot be a fiduciary as a custodian in some cases.
Mr. Bishop, can you say that one more time?
If you're a fiduciary, you can be a custodian of those assets. You can hold those assets for your customers and still have a fiduciary responsibility to manage those assets. However, if you are just a custodian and you are not allowed to have fiduciary powers, you cannot be that fiduciary. You cannot manage those in some circumstances.
Mr. Bishop, would that be something that could be detailed in the trust instrument that governs the relationship?
Yes, Mr. Chairman, most likely. Yes, exactly. That's in that customer agreement. What are you allowed to do on behalf of your customer? Do you have fiduciary powers or not? Or do you just have purely custodial powers where you're holding them and say keeping them? That is very much determined by the I'd say the customer agreement. What are you allowed to do on their behalf? And then also, for example, like you can't do trust business, which includes acting as a fiduciary or trustee, unless you're eligible to be a trustee, which means a chartered trust company or a bank. No one else can be a trustee. So there's going through this. I think this was one of the major issues of this bill, was removing the language of trust and fiduciary services. From the definition of custodial services. That was one of my actually main problems with this draft bill at the last meeting, was that we've been using that definition of custodial service to include trust and fiduciary powers in some cases since the 342104 was created. So businesses have actually made their entire business plan using that definition. And so during that working group, that's one of the ones we brought up. Hey, if you're going to carve this out, you need to insert it back in somewhere. You can't just carve trust and fiduciary from 3429-104. You must address that somewhere else. So I think that's what drove this two definitions breaking out. And so then, okay, you need to make sure that the rest of 3429-104 does apply to fiduciary services when applicable.
Ms. Co-Chair, please.
Commissioner, but custodial services are almost like a switch. Do I have custodial services, yes or no? Which means, and maybe it doesn't always mean this, but in my mind, it means I am the holder, the responsible holder of that asset. And at that custodial level, I'm either holding it or I'm not. Yes or no? You're the custodian of it, yes or no? And then I can layer on top of that, in my mind, and this might not be the legal way to look at it, but in my mind, I can layer on, you have more responsibilities, including fiduciary responsibility to the asset that you have in custody, yes or no? But you describe them as potentially mutually exclusive because okay. So that's what I'm trying to get at, because fiduciary, it seems like layers where I layer on fiduciary responsibility. Is there a circumstance where I could have fiduciary responsibility without having custody?
Mr. Chairman.
Mr. Bishop, please.
Yep, Mr. Senator Roth, yes, you could be a fiduciary and not have custody of those assets. That actually happens in most cases. You're the fiduciary, you use a sub-custodian. Someone else is holding it for you. And to your point, yes, you could be a custodian, you hold it or you don't. And on top of that, you could have fiduciary powers, exercise of discretion. Yes, that could be the same entity. Now, some custodians don't have the authority to be a fiduciary.
Right.
So yes, they do layer on top of each other, and they're not mutually exclusive. They do overlap in some cases.
So they can't, so you've got two switches, either can be on or off, basically, and all of those situations can take place. And so that's how we have to construct our definitions, and I don't think they're constructed quite that way. And we should be able to get to the point where, getting back to the idea of, on page 8, this sentence that I think is going to be a challenge, the term custodial services shall include fiduciary services in this section unless the context otherwise requires it. We probably need to get to a point where custodial services, well, I guess that is a separate question. That becomes nuanced. If I don't have custody, but I'm a sub-custodian and I have fiduciary services, does everything above, or does everything in this section apply? That becomes fairly complicated. So I'm the fiduciary, but not the custodian, is an interesting edge case to think through with regard to.
Mr. Chairman?
Mr. Revelle, please, go ahead.
Yes, thank you, Mr. Chairman. I want to back up to the commissioner's comment about being a fiduciary but not a custodian, and just spend a minute there clarifying that. Because I think that the intent right now of the working group differs from that read of it. So I think it's worth spending a moment here. I wanted to explore with the commissioner this more specifics around the situation where you could be a fiduciary but not a custodian, and are we, I guess, do we need to distinguish between a trust fiduciary and an investment fiduciary as part of this discussion?
Commissioner, please.
Yes, thank you, Mr. Chairman. Yes, Mr. River. Yeah, I agree. There is a difference between maybe a trust fiduciary and an investment fiduciary. Those are very different things between an asset manager or investment management services, which is a fiduciary, or are you basically acting on trustee on behalf of your grantor and beneficiaries? Those are different. Now, whether or not we need to distinguish those in 3429-104, I am not sure. I think we might be going a little further than, like Mr. Evans said, what the working group is really trying to do here. And again, this is 3429-104, that's digital asset custodial services. So we're just trying to input, making sure that the definition of custodial services includes, I think, fiduciary and trust powers like it always has. I think that's the main idea for breaking this out, was making sure that you don't materially change the definition of custodial services from what's been in place since this law was originally passed. I think that was the whole point, was to make sure that that remains consistent. And I think the working group has done that by splitting these two, custodial services definition, pulling out trust and fiduciary, adding itself. Now we just got to make sure that it reconciles with the rest of 3429-104. I think that's the main purpose here. And so I think the way this is worded in this page 8 is just then going through the rest of 3429-104 and making sure that we know when to distinguish one from the other, or do we even need to at all? Is it always, if you just reference custodial services, does it always include trust and fiduciary? I think that was the intent. I think, but someone will, since it's stated this way, to Senator Rothfuss's point, we're going to have to go through line by line in 3429-104 and identify exactly which ones include both or one or the other.
Mr.
Mr. Chairman, oh, sorry.
No, that's all right.
Just for the edification committee, could you just define the difference between those two fiduciaries that you mentioned?
Yes, Mr. Chairman, this is something I think that Mr. Revel mentioned, whether or not you are fiduciary power through an investment manager, so you have, or through a trustee relationship. So, for example, there are investment management companies. You can be a wealth manager out there. However, you may not be an actual trust company doing trust company business. So in a Wyoming law, that's the difference, is that definition of trust company
Thank you.
business.
Just want to make
versus
sure
management.
the audits and the committee is all on the same page. I think, Mr. Revelle, did you want to jump in there?
Yeah, actually, I was just going to make a comment, but I'd like to defer to Mr. Evans if I could,
course.
who I think it should probably jump in here at this point because we've kind of wandered onto some new territory.
Mr. Evans, please, go ahead.
Sorry, thank you, Mr. Chairman. So the entities that can conduct fiduciary services in this context, we're talking about trusts and speedies. They are also able to conduct custodial services under this definition. So I believe that the co-chairman's distinction was right on the Venn diagram where there are certain services, fiduciary services, that involve substantial discretion. But those entities that can conduct those services may also conduct custodial services, which have lesser discretion. And the purpose of this bill is to make sure that both custodial services and fiduciary services maintain the same bankruptcy protections, that the customer's assets are protected for both custodial and fiduciary services. And I think we got a little off track with sub-custodian versus custodian. I think that the point is that the entities that are authorized to conduct fiduciary services and that can custody digital assets can provide both custodial and fiduciary services.
Mr. Evans, and following up on that thought, just in a bankruptcy court, how much difference will it make when a judge is looking at, okay, this is the custodial services are done in-house by this trust or that they are contracted out to a third party?
So it's a good
How much of a
question.
difference will that make?
It's a good question. The reason why what we're doing here matters so much, in my view, is whether there is what they refer to as a trust relationship in the bankruptcy court defers to state law. And so the bankruptcy court will turn to Wyoming and say, what is a trust relationship under Wyoming? What is a bankruptcy protected asset under Wyoming law? And so when you look at these cases, and we're involved in nearly all of them, and the state laws on these subjects, very limited. And so the question as to custody and sub-custody, I haven't seen that distinction with any bankruptcy judge in any of the crypto bankruptcy cases, but they would look at very similar things, in my view, to what you would look at if you had a direct custodial relationship. And the question is going to turn on commingling of company and customer assets. And the control should be in the hands of the custodian, which in this case would be the registered entity that has the ability to conduct fiduciary and custodial services in Wyoming.
Mr. Co-Chair, please. Thank you, by the way, for that clarification. Go ahead.
So as I'm looking on page 9 now at the definitions, where we have the definition of custodial services in existing statute, and then we add fiduciary services, and the way the statutory construct here is, it does make them mutually exclusive. I guess the question I have for simplicity is, if rather than creating a new definition on Romanet 3, in the struck language on line 21, instead of it saying this term includes the exercise of fiduciary and trust powers, if we had it say this term may include the exercise of fiduciary and trust powers involving the exercise of discretion, and then capture the extended language of discretion, including currency, digital assets, securities, and commodities, so that at that point, for the purposes of, and this is in the digital asset portion of statute, this isn't in the banking title, but it would basically say that for the purposes of this section, it may or may not include fiduciary services, but within custodial. Does that achieve the interests that you're looking for in this section? It sounds like it does based on what Mr. Evans just laid out, but I'm just trying to see if I'm missing something there.
Mr. Revelle? Or was that?
Yes, I believe it does. I would actually ask Mr. Evans the
Mr.
same
Evans.
question.
Please, go ahead.
Yes, Mr. Chairman, I believe it does. I think that the tension with the drafting is we understand that there is an effort to more clearly define what's custodial versus what's fiduciary in general, and maybe not for this particular context. But yes, I do think that's a viable solution.
Mr. Co-Chair?
If there's that desire, one alternative could be looking back at that language, custodial services means the safekeeping, et cetera. This term may include the exercise of fiduciary services, we'll say arbitrarily. And then you could have fiduciary services as a separate definition, but that does seem to dirty it up. But all right, I think realistically, Mr. Chairman, this discussion needs a little bit more time in the working group based on what we've just talked about, and I think we can come up with something that dramatically simplifies it, so.
Mr. Co-Chairman,
Yeah.
like good legislators, we want to solve this.
We want to do it right now,
We want
but
to solve it right now, my God.
in the interest of time, doing it later might be the right choice.
With the danger of going down the rabbit hole quite quickly, there is more, we can put more time on the clock with this particular bill. I think to that end, or Mr. Ravel or Mr. Evans, was there anything else you want to tack on before we try to move on?
Nothing further. Thank you, Mr. Chairman.
Nothing for me. Thank you, Mr. Chairman.
Commissioner?
Yes, I do have a few more things.
Yeah, please go ahead.
Much more technical than that one, so hopefully they'll go a little bit quicker. This is more, again, just technical in language, but on page 2, again, this is in Title 13. It refers to custodial fiduciary accounts. And then on page 9 and 10, it's custodial and fiduciary services. I don't know if that needs to reconcile with each other. That might be something that can be discussed along when you're tackling this.
Could you repeat that one more time?
Yeah,
Mr. Bishop?
page 2, again, this is in 13.1.206. It's custodial or fiduciary accounts. Whereas on 34.29.104, which is addressed on pages 9 and 10, it's custodial and fiduciary services. Now, that means an account. So I'd have to defer maybe to someone else on whether or not that's an issue or not, or whether or not those should be the same verbiage. I just don't know.
Mr. Chairman, my thought, I think that's a valid point. Should we save that for when the working group reconvenes, or do we want to elaborate now?
No, I think we just mark that down, make sure David's
Okay.
got it, and that we need to address that.
Mr. Hopkinson, do you want us to repeat that, or you think you got it? Mr. Commissioner, please
A few other
continue.
things that this does, I also like I said, it adds the new P to 34.29.104 to include trust companies. So I would suggest that if we are adding trust companies to 34.29.104, there is a difference under Title 13 of a trust company versus a supervised trust company. And so anywhere that it references actually a bank currently under 34.29.104, I think the past version of this only applied to banks. If we're adding in trust companies, one, make the new P say a supervised trust company, and then elsewhere throughout all of 34.29.104, where it says bank, it needs to be bank or supervised trust company to include, just to show that supervised trust companies are included basically in the definition of bank. There's several ways I think you could do this. You could actually just do that, go all the way through, or you could add some definition in 34.29.104 of maybe financial institution as defined in Title 13, which does include banks or trust companies. But just want to make sure that there is no question that supervised trust companies, when providing these services, must comply with all of 34.29.104. So again, this is a little bit more technical, just making sure the verbiage is put in throughout. And just, I guess, for background, the difference between a trust company and supervised trust company is ones that the division supervises. There are private family trust companies that are not actually chartered, we don't supervise, and so that's that main difference. Now, the ones that we'll be worried about on this is those supervised companies, so that's why I think it'd be a good idea to include that supervised language.
Good point.
Ms. Co-Chair?
Yep, good point. Thank you, Mr. Chairman.
Commissioner, continue.
I think those were all the comments I had, so see if there's any questions.
Committee, any questions for the commissioner? Again, I think, as you clearly saw, there's still some debate that needs to be sussed out about that relationship. So we'll punt most of that towards the the sake of time, let's punt that towards when the working group reconvenes. But that being said, is there any further questions for the commissioner? Seeing none. Thank you very much, Commissioner Bishop. So I know on the agenda, this also has the banking division, classification, and salary exemptions. Well, let's get this, dispose of this question before we move on to that one. Is there any public comment in the room on this particular topic? Please go ahead. And if you just state your name and who you're with, please.
Good morning, Lisa Jerdy Spellman. I'm here with SAFE, is a supervised regulated trust company. Thank you, Mr. Chairman. Mr. Chairman.
Could you repeat your name one more time?
Lisa Jerdy Spellman.
Please proceed.
Thank you, Mr. Chair. I appreciated all the work of the committee on the revisions to this bill. I agree with the commissioner's comment with respect to providing express authority within this bill for supervised trust companies. We also would agree that the statute could be amended to include bank or supervised trust companies throughout the provisions and including the new section P.
Excellent.
Excellent. Committee members, any questions? Seeing none, thank you very much for your comments.
Thank you.
Thank you very much.
Anybody else in the room that wants to testify on this one? Closer, do we have anybody in Zoom land? Doesn't look like it. Well, seeing that public testimony is closed, Mr. Co-Chair, Mr. Hopkinson?
I just wanted to bring up one more potential amendment to consider is.
Please do.
This either goes to the working group, however the committee decides to proceed, and that was Commissioner Bishop brought up on page 2, the custodial or fiduciary accounts and discussed, making those definitions consistent in 13.1.206 and 34.29.104. But I also see in that definition there on page 2, or that first subsection, it talks about custodial or fiduciary accounts, and later on line 9, shall not be deemed assets or liabilities. So it kind of makes the account an asset or a liability, and should that instead, be referred to the actual asset or liability, or excuse me, actual, the actual digital asset or whatever, as opposed to the account being an asset or a liability, but the actual asset. And the same thing on page 10, we've got the custodial services, and that references, financial assets and things of that nature. Whereas with fiduciary services, it means an account established by, and references instead an account as opposed to the asset. And so I just think maybe there might need to be some discussion on conforming those to each other.
Mr. Hopkins, thank you. I think that's a valid point. Certainly, at least my thought, referencing page 10 right there, you could simply say financial for fiduciary services means an account and the assets it holds. Could be at least a potential way to eliminate some of that confusion. Mr. Co-Chair?
Yeah, I think this will take a little bit of work, honestly, because services are not the same as an account, even though there's an account associated with the services. And you have assets in the account as opposed to the accounts themselves, which is what Mr. Hopkinson is talking about. So I think combing through it and getting some consistency in that terminology will be an important step. And it can be, whether it's holdings or assets within. Assets probably makes the most sense. Assets within custodial or fiduciary accounts under the administration or management is a way to say that, so that you're at that point talking about the assets as being off the balance sheet as opposed to the accounts themselves. And I think that's a good catch. So that, I think we add that to the list of steps that need to be taken before we have this bill ready for sponsorship, is ensuring that we have consistency in the language of accounts, services, and assets, and that all of that aligns appropriately.
Mr. Co-Chair, Joseph Evans from McDermott.
Mr. Evans, please go ahead.
On pages 6 and 7, there are definitions of custodial account and fiduciary account. And wherever we land on custodial services and fiduciary services, we'll have to correspond with this section too, but there are definitions for accounts versus services, but I agree, we'll need to comb through both of them.
Mr. Evans, I think that's a valid point in making sure that we're consistent, whether it's the entirely new language we're putting in 206 or the stuff that we are amending. So I think that's Mr. Hopkinson. We'll make sure we get that. So when the working group reconvenes, we can take this under consideration for agenda items. Is there any further comment by the committee? So I think we'll handle this one the same way we just handled the open banking stuff. Given that there are no more scheduled meetings by the Minerals Committee which we have to go through because this does deal with Title 13. The thought is, let's reconvene the working group and then we can run this as an individual bill. And of course, encouraging members of this committee to co-sponsor, we can bring it forth as an individual. I think it's good just because there's still some, I think it's really well crafted. I think there's still a couple of key questions that we need to hash out. So if there are no objections, I'm going to table this bill. Mr. Co-Chair, is that?
Any quick comments?
Any last minute comments? I think everyone's, I'm not seeing anybody raise their hands and shout and scream. So yeah, let's go ahead and postpone for the consideration. So up next, we're still on agenda item number 3. Let's work through 24 LSO 0258, Banking Division Classification and Salary Exemptions. Mr. Bishop, Mr. Hopkinson, let's follow the process. Let's have you walk through us first, and then of course we'll have Mr. Bishop. And I think give a little context for the folks listening. The Cliff Note version is that the division has a lot of these positions that are highly sophisticated in terms of what is required of these people. And the reality is that there's not a lot of people who have the expertise, and that pool shrinks even further of the folks who are interested in doing this from a regulatory perspective. And so we think that having these, allowing them to pay more would be a way we can address this, and having these examiners that specifically deal with these digital banks, because it's an issue. So that's some of the background for the committee. Mr. Co-Chair, you want to hop in?
Yeah, Mr. Chairman, I'll just note for the committee that at the Minerals Committee meeting last week, and it was passed by the Minerals Committee, but it was passed with a directive to us, some conditions, I guess I'll say, that we address one key concern related to the concern that Mr. Bishop has raised with the, we'll say, agent of action of this legislation, where the banking board would be proposing, and we'll see that as we walk through it, changes in salary, and that was a concern for conflict of interest. So one thing that we are then responsible for, even though this is a minerals bill, a Minerals Committee piece of legislation will be introduced as a Minerals Committee bill, is that factor of cleaning up how the process ends up going forward. So we can talk about that a little bit more, but for context, this has actually already been sponsored by the Minerals Committee, but we are nonetheless the responsible body for actually getting it across the finish line. The Minerals Committee is just letting us take the ball and run with it as long as we get it right. And with that,
essentially, we're getting a re-referral here.
yeah.
Mr. Hopkinson, please take it away.
Thank you, Mr. Chairman. David Hopkinson with the Legislative Service Office, walking through 24 LSO 0258, Banking Division Classification and Salary Exemptions. This draft goes into, and really, this version doesn't have any changes other than some statutory updates from the version that the committee looked at the last meeting. What the bill draft does is it goes into the banking board statute and adds a new paragraph under subsection B, creating new paragraph 8. And that essentially the new language there takes, with the exception of the salary of the commissioner, it would allow the banking board to establish classifications and salaries for the division of banking in consultation with the director and subject to legislative appropriation. And it then removes authority to provide classifications and salary from ANI, which is what we see down on lines 19 and 20. Instead, that would again, be determined by the banking board. It provides that the specialized skills required to supervise the speedy banks and financial technology shall be defined by the state banking commissioner. And it provides that the creation of the classifications and salaries for the division of banking, and prior to the increase of any person's salary pursuant to this paragraph, that the division would report the classifications and salaries to the Joint Appropriations Committee. This is over on page 3. Then finally, any salary increases requested would be included in the department's exception budget. Section 2 requires that no increase in a person's salary would be effective until approved by the governor. And the act would be effective July 1st, 2024. And with that, I'd stand for any questions on the draft itself.
Committee members, any questions for Mr. Hopkinson? And so just for the edification of the committee, obviously the meat right there is on page 2 where it says, B, the banking board shall, so meaning it's promulgated under the authority and that they are the governing body of this process. Is that a fair understanding? Mr. Hopkinson?
Well, Mr. Chairman, the draft would give them the authority to do this, to create those salaries and classifications and set salaries of employees.
And thank you, Mr. Hopkinson. The reason I asked that, committee members, is because that there was some concern that was expressed at the Minerals Committee that, while obviously well-intentioned, and we're trying to carve out this protocol, that given the composition of the banking board and what it's made up, there could be a potential conflict of interest, given that they would be, through this process, setting the salaries of some of these employees. And so that was an issue that was expressed, and part of the reason why it was passed out of Minerals, and we referred under the condition that we would potentially, that we would properly address that conflict of interest. So I just wanted to make sure the committee is on the same page. Mr. Co-Chair, you have any? Okay. Thank you, Mr. Hopkinson. Nope. Representative Singh, go ahead.
Thank you, Mr. Chairman and Mr. Hopkinson. My question is, are there any other types of personnel that require gubernatorial approval for their raises?
Mr. Hopkinson, please, go ahead.
Thank you, Mr. Chairman. I would have to get back to you on that. I'm not aware of any off the top of my head, other than, of course, people in his own office, but I will get back to you on that.
Seeing no further questions, let's go ahead and bring Commissioner Bishop up.
Thank you, Mr. Chairman. Again, Jeremiah Bishop, Banking Commissioner for the Division of Banking. Again, I'd like to thank the committee for looking at this problem. I'm not going to dive as much into what the actual problem is as I have before, as I think we all understand that. I think what I will do is walk through kind of what our current process is for just general budget requests and how that might work with this. And then again, I know that the direction from the Minerals Committee was that this conflict of interest between the banking board setting salaries of the division needs to be addressed by this committee. So I guess I'd start off by just posing the question was, with this bill being under the banking board, I guess I'm not sure, I'd ask what the purpose of having it under the banking board serves. So I agree that I shouldn't just have unilateral authority to pay our division staff without question whatever I want. There needs to be some checks and balances in place and some review and other approval outside of maybe even the division or even the Department of Audit. And so our current process, for example, we just did this last year. We did some salary increases. We did it through the traditional budget process. So that first must go to the budget department and the governor's office for approval. And then assuming it gets approved by the governor, and then it goes to the appropriations committee, and then it gets voted on by the appropriations and then the legislature as a whole. That did happen this last time, and I will say that process worked really well. What I did is I have access to that information of other states in the country and also our areas of what their salaries are for traditional bank and trust company and other supervision among other institutions we regulate. We do quite a bit more than banks, trust companies, and speedies. I have access to that information. It's provided by a Conference of State Bank Supervisors, CSBS. They do an annual survey of all 50 states, and that's where I get that information from. And so realistically, if we were to start addressing salaries on a most likely every 2-year basis, because that's our budget cycle, I would start with that, like, okay, our traditional examiners, how are they being paid or compensated compared to other states doing identical supervisory work? Traditional banks, trust companies, money transmitters, mortgage company, things like that. Then we would look at, okay, what duties or what skills do we need for some of these unique activity we're regulating, such as digital assets, some speedies, some of these other activities that these other states may not even be supervising at all. I would then probably present that to the governors through this process for approval, along with my report that supports that. If the governor signs off, it then goes to appropriations upon approval. So adding this other layer of the banking board, I guess that's my question, is what check and balance does that serve? The governor and appropriations isn't already covering. And if there does need to be somebody else besides the governor and appropriations committee, by all means, I'm open for that. That's my main question. I can't provide too much of an answer there because I think that's for you all to decide. But I guess that was the question I had, was what if we just followed our traditional budget procedures, get it signed off by the governor, appropriations, and then making sure it's consistent. Again, if this passes, I'll likely have to create this an internal policy. How do we go about this so that it's not just arbitrary on how we set salaries? We do actually get reviewed by CSBS regularly. This is something I already have to do, is come up with the case of a plan for this. So I'm going to be doing this anyways, but that's one fix, is I just come up with some type of policy so I can't do whatever I want. Without any questions or comments.
Thank you, Mr. Chairman. So with that, if you have, again, taking the board out, we understand the conflict of interest there, but if you effectively established it so that you would put forward the classifications, define those classifications, define appropriate salaries for those classifications, and then rather than having that go through the current full process where it now has to be aligned with A&I classifications, if it just went from that point up to the governor signs off on it, it goes through appropriations, that then gets you the flexibility that we want to see you have, but with sufficient oversight so that you can't grade your own homework. Is that fair?
Commissioner Bishop.
Thank you, Mr. Chairman, Senator Rothfuss. Yes, I think if what this does is basically exempts division staff and classifications, exempts them from A&I personnel requirements. I can then get to create, or somebody creates classifications and salary amounts, and then it gets approved by 2 different entities. My understanding is that's what this would do. Now, I guess the question is, should I be the one doing that? Should the director, that's the director of the Department of Audit, that's who this refers to, in consult, I think that part's already built in. The director makes those requests. So is there another, should that have some other entity besides the banking board, or should we just get rid of the banking board together and just let it go through myself, the director, the governor, appropriations, as long as we're exempt from A&I classification, and we can kind of create our own job classifications and salary amounts?
Well, I guess, Mr. Coach, I think that's certainly valid. Coming back to the genesis of this, what was the original intent, the idea, and the problem we're trying to solve? And I think that is that, given the unique demands of some of these speedy banks and the regulation required of them and the expertise to enforce that regulation, I believe that was kind of the genesis of all this. And certainly we could certainly open this up more broadly to all the scope of responsibilities that you have, but at least that was my recollection of us focusing specifically on as it relates to these speedy banks, where what you're talking about is let's just open the whole shebang up, but which I'm not saying isn't a valid topic of discussion, because I think I have my own frustrations with the process that's currently on the books, but just making sure we have that delineation. Mr. Co-Chair.
Mr. Chairman, I don't think that's what he's asking. I think he's just saying this includes the board, the banking board. do this, but without the banking board.
Right.
And at that point, for the Division of Banking, so they wouldn't have to seek approval from the board. It would be prepared all internally, and then you go through the process where you're going to need the governor's approval. You're going to need to take it to appropriations, but you don't have the classification boundaries, which the classification boundaries are the problem, is that they're trying to work within classifications that don't fit what they have. So this removes, it exempts them effectively for, let's see, looks like lines 19 and 20, I believe, are taking the classification aspect off, so that they can write their own job descriptions for what they actually do. And then it says above, come up with salaries that are appropriate. Do we need to move around more, or? There we go. All right.
We're just that exciting to watch, Mr. Co-Chair.
We have been so dynamic that the lights shut off on us. That's
Even the lights got bored.
I feel like we're underperforming. All right, more dancing. Mr. Chairman, so I think it does exactly what we're looking for, but takes out that potential conflict, and I think that's an appropriate solution.
Committee members, any questions? Senator Furphy, please go ahead.
Thank you, Mr. Chairman. Let me ask the Commissioner. Is it possible to train your existing staff, or are you going to have to hire several new employees? Thank you.
Commissioner Bishop.
Yep, thank you, Mr. Chairman. Senator Furphy, assuming that you're discussing, the digital asset examiners, PD examiners, trust company examiners that involve in digital asset activity, I would love to be able to hire people. I've been trying to. I've not found anybody with direct expertise that knows both banks, trust company business, as well as digital asset activity. So we have been training internally all of our staff in this area. What we have basically been forced to do is, if you are a bank or trust examiner, you are now also a speedy trust company digital asset examiner. And we hire people, make that known that you will be doing this, and then we train internally on how to do this. There's not a lot of training out there on this, but we have found some, and we've been doing a lot of hands-on training as well. I would love to hire people externally that have that. I try. If I see one, I'll pay them a lot of attention. But yeah, it's ideally a combination of both.
Mr. Co-Chair, or Mr. Senator Furphy, did you have a follow-up? I'm going to follow up, Mr. Co-Chair.
Mr. Chairman, I was just going to say, and Commissioner Bishop mentioned that their turnover since 2019 was over 100% turnover effectively, because I think we're an excellent training ground for the very few banking examiners that understand digital assets, and you can imagine how then lucrative that is when they're not available on the market, and when we underpaid due to underclassification. We are just that. We're a short-term training ground for exceptionally qualified and highly demanded banking examiners, and so we're more of a school than a than a fully functional commission at any given time, unfortunately, or division at any given time.
VOTEC instructor is not part of the duties and responsibilities of the banking commissioner, last I checked. Committee members, not seeing any further discussion or questions for the commissioner. Please do, of course, stick around just in case. Let's go and open this one up to public comment. Mr. Meyer, please. Mr. Meyer, we know who you are, but you know the process.
Mr. Commissioner, members of the Select Committee, Scott Meyer on behalf of the Wyoming Bankers Association. First, I'd like to just say that I echo the Commissioner's comments regarding the State Board. Most of those, other than one, are bankers. We don't want to be in the position of saying, let's set the salary here and then give some kind of an air of conflict. I think the other comment I'd like to make too, and with no disrespect to the two chairmen, but this isn't just about speedy banks. This is about regulators in general. This is why this is so important for the banking industry. It makes us look good when we have good regulators. And right now we don't have enough. And we are a training ground. So this affects not only the speedy banks, but it affects every community bank that's out there. when we're doing the training, and then they come back and 2 or 3 years later, they're gone and it's somebody else. It doesn't give us a very good feeling, and it doesn't give the public a very good feeling. And I do hear comments that, well, yes, the state treasurer has people that do a lot of investing. Now, maybe they are special because they're dealing with a lot of money, or maybe DEQ's got some people in there and they're special, and they need to have some special consideration. My only comment is that the way the classifications work right now, these are auditors. And what can an auditor do to you? Well, they can give you a black mark. You can put something in a report. What they have now is, even though they're classified as auditors, they have regulators. These guys can take my charter right off of my wall. That stops everything. That is a big deal. That's a big deal to banking. And so it's important that we not only have the right people in there, that we pay the right people to keep them in there to make our industry and make this state look good. And so it's imperative that we be able to pay those people what we need to keep them in there just for that purpose. And for that, Mr. Co-Chairman and Mr. Chairman, stand for any questions.
Committee members, any questions? Scott, I do have a question. So are you encouraging, or I guess open to the idea or suggesting, or however you want to word it, that we open this up more broadly across? Because right now, obviously, this is targeted specifically at inspections for these speedy banks. So are you trying to open up more broadly just to all the roles and responsibilities of the division as regards to these institutions?
Mr. Chairman, I would encourage that. I think that all the regulators that the Division of Banking oversees they have to have the right people, and in order to do that, they have to be able to pay them. So yes, I would open it up to all regulators under the Division of Banking.
Mr. Co-Chairman.
Yeah, I don't think as structured it currently is narrowed to speedy banks. It just talks about the fact that those specialized skills need to be incorporated into classification so that we have people that are capable of doing that. But it is structured such that the entire Division of Banking has the capacity to set its own classifications and internal salary schedules associated with it, I believe. And
I guess
that seems like where we should be.
I'm trying to think. I guess, Mr. Co-Chair, what it does say, it says they has to be posted in the description, but not necessarily contingent upon their hiring.
Well, as this is structured at the bottom of page 2, it's upon creation of the classifications and salaries for the Division of Banking. The division shall report classifications and salaries to the General Appropriations Committee, but the concept really is writ large for the full Division of Banking, I believe. I don't think we.
Mr. Hopkinson, could you provide any clarity on that one? If it's as written, specifically tailored for examiners for speedy banks, or if this can be a broadly across all the responsibilities of the commission in the Division of Banking.
Yeah. Mr. Chairman, we look at line 8, establish personnel classifications and salaries for the Division of Banking. That's what this does. Everything else is modifying that. So it's fully, everything within the Division of Banking is then subject to this, which I think is appropriate.
Yeah, it just simply talks that the commissioner has to include the description of the specialized skills, but not necessarily contingent upon the hiring thereof for those employees.
Yeah.
Back to Mr. Meyer. So I appreciate your clarification that this is important, that it's broad-based and not just specifically for these types of banks. Committee members, any questions for Mr. Meyer? Seeing none. Thank you very much. We appreciate your time. Anybody else in the room that wants to testify or give comments? Anybody in Zoom world? I don't think I saw on our list. So we're going to go ahead and close public testimony. Again, this is yet another Title 13 bill. So if we're going to bring this to session, it's going to have to be on a personal basis. I think, Mr. Co-Chair, go ahead.
No, the bill's already sponsored by Minerals. It's just up to us to come up with an amendment that conforms to what we discussed.
Thank you, Mr. Co-Chair. Remind me, was that That would have been an amendment that we'd have to run during committee.
Yep.
Right.
So we won't be able to amend it here. It really was to discuss it and see what we're all comfortable with. Where I'm inclined to agree with Commissioner Bishop that if we simply remove the banking board from this process and have flexible classifications, they come up with their own classifications internally, propose some salaries, that goes through the governor, and then goes through the budget process. That is going to be functional. It's what they do now in the absence of prescribed classifications. So we're basically releasing them from classifications and narrowing it down to that, where they have the ability to write their own classifications and determine what appropriate salaries are for those classifications internally, and then go through the proposed budget process, which provides the necessary check. You've got the governor and you still have appropriations committee.
Right, so long as we continue to map it to the language in lines
Yep.
19 through 20 and that,
Yep.
that Title IX, E&I language. Mr. Co-Chair, my thought would be, perhaps you and I, we can have our own little working group and work
Yeah, we'll
up an
just work
amendment.
up an amendment, figure
Unless,
out where to go.
is there anybody, committee members who want to contribute to this? I'm not seeing any hands, people jumping out of their chairs, so
And is everyone comfortable with that idea? Yeah,
it looks like it.
good, perfect.
Excellent, so absent objection, Mr. Co-Chair and I will, our own little working group. So I think it's 10:46, so we're
Great time.
just 15 minutes behind, but let's go ahead and take a 10-minute break. So it's 10:46, so at 10:56, let's all be back in here to take up the agenda item number 5, the stable token. Clarissa, are we live again? Okay. So next up is agenda item number 3, or excuse me, number 5, pardon me. We've got update on the Wyoming stable token. So let's get Apollo and Flavia up here. I'm sure some of the folks who've been following, there's been a lot of work by the commission, by the new our new director, and there's been a lot of blood, sweat, and tears poured into this one. So let's just kind of start with an update. I think, Apollo, do you want to? There was a report that was sent to us last month. I think it did a really good job detailing where things are at now, what is needed from the legislature, from the select committee. So, Apollo, maybe you want to touch on that a little bit first?
I am the Executive Director of the Stable Token Commission, and today I am joined by
Flavia Navis. I'm one of the commissioners appointed to the Stable Token Commission.
I'd also like to point out that we have Commissioner David Pope with us as well, and Commissioner Joel Revelle on the line. I would quickly like to confirm that we have no other commissioners of the Stable Token Commission on the line, as that would inadvertently create a meeting for us within a meeting. So I will let anyone chirp up and drop out if they need to. Hearing none, I will dive into a fairly high-level view of the legislative report that was sent from my office to the Select Committee on November 1st. This is available on our website, which is stabletoken.yo.gov. It's kind of buried in the meetings that we've got listed on the site. I'm going to be restructuring all of that, so it'll be a little easier to find, but it is publicly available and has been since then. So first and foremost, we have an executive summary from my side. This is pretty much a snapshot in time of the progress that the commission had made to date as of November 1st, with a couple of important things called out, including my onboarding on September 18th, our engagement of Paul Hastings LLP as consultant regarding securities law towards the end of October, several versions of our business plan going out, which specify that we're moving forward with a settlement token model similar to the USDC token issued by Circle. Our subcommittees that have been working to date were broken up into smaller working groups. They'll be more tactical and granular. We've only spent about $25K out of a $500,000 budget to date. We anticipate requesting a budget allocation of $8 to $12 million for the 2024 to 2025 biennium. And at this point in time, we do not believe that there is anything impeding us, legally speaking, from issuing a stable token. One important caveat here, we do mention that we were looking to issue a test token by the end of the year to satisfy our requirements to endeavor to issue the first stable token by the end of the year. That requirement has been met. We'll talk about that a bit more in a minute. And again, I would thank the co-chairs for their letter to the commission. Diving in, just to flow through the rest of the report relatively quickly. There is a letter from the director here, perhaps a bit of editorializing on my side, but to give a snapshot of what the stable token industry looks like, it is a $125 billion industry. There are no government entities in that at this point in time, although there are some stable token efforts being spun up, which I highlight here. And the point of this is to kind of give some steps at high-level steps for what we're building around, our legal framework, creating an economic model, developing a code base, and also just working through a bit of an educational effort to make sure everyone's aware of what the heck it is we're actually building here. Moving on to regulatory considerations. This again identifies the structure we are pursuing in terms of what the stable token will look like. We highlight many existing domestic and international legal frameworks that may or may not be applicable based on how we structure this. And again, reiterate here that we are going to continue moving forward. We do not have any belief that anything's precluding us from issuing a token in the near future. Moving on to statutes and policies, this is where our office highlighted a couple of pieces in the act where we'd want to update the wording to give us a little bit more clarity or leeway in what could be developed over time. Again, I'll waive that for the time being because we'll go through that in more detail. We review the bill. In terms of financial considerations, again, I already mentioned the range of potential budget we'd be asking for. I will reiterate that This is an estimate for the time being. We are moving into our potential procurement process, starting with a request for information period over the next 30 days, followed by the formal RFP period. We'll be using the information gathered in that time to refine these numbers. One of the things I want to point out is just how large the scope of this project will be. We call out about 17 functions here, and most recently in the RFI we put out, there are multiple different features we'll need to be built out across legal, financial, technical, operations, and all of that is detailed both in this report and more recently in the RFI. And then finally, the development roadmap we have here, breaking this up in a very startup kind of way into private alphas, private and public betas before full launch. And net, we believe this is something that we could issue a fully reserved Wyoming stable token by the end of next year. Again, some of this has changed as a result of receiving the letter from the select committee, and I'm happy to kind of cover that quickly or stand for any questions the committee may already have.
Commissioner, let's just take a director break real quick. Is anybody, any questions thus far for the director? Please proceed.
Thank you, Mr. Chairman. So again, my report was delivered on November 1st. 1 week later, on November 8th, the Stable Token Commission received a letter from the Select Committee, essentially saying that the Wyoming Stable Token Committee has met its obligations required by Chapter 185, Section 2A of the 2023 Wyoming Session Laws, and that we have thoroughly endeavored to issue a Wyoming Stable Token and met our obligations. So with that being said, our office is no longer pursuing the issuance of a test token by the end of the year, which I had stated and do believe would have been feasible. However, it was causing us to go in a bunch of different directions, to be quite candid, to meet that deadline. As a result, I believe we have a more unified focus moving forward here. And I'll also call out a few other particulars of the letter received. One is that the Select Committee expects us to achieve a widespread release as quickly as prudent, and that they also encourage a multi-chain, technology-neutral approach. So rather than having to perform a ton of analysis, pick a blockchain, build a test token, and then know that we're going to move on to other chains in due time, we can have a more agnostic and holistic approach from the get-go. And I certainly appreciate that, and will speak on behalf of the Stable Token Commission. I think most of us appreciate that. So thank you. Any questions on the report or the letter received in response?
Members, Senator Furphy, please go ahead.
Thank you, Mr. Chairman. Curious, what is the minimum purchase that you would allow? I assume you don't want too small, too complicated to manage smaller ones. Is it like $10,000 minimum, or what is the range? Thank you.
Director Powell, please go ahead.
Through the chair. Thank you, Senator Furphy. There is no minimum purchase price defined at this point in time for an initial allocation of Wyoming stable tokens. That being said, the assumption, and as is currently documented in our business plan, is that we will be starting with institutional sales rather than retail customers. So we would expect that to be, $10,000, $100,000, probably somewhere in that range. I do believe that Circle recently did put out guidance that they're no longer going to be serving retail customers directly, and I believe their institutional limit is $100,000, if that is a point of reference.
Senator Furphy, any follow-up? Seeing none. Director, please continue.
Excellent. Thank you, Mr. Chairman. If it would appease the committee, I will begin working through some of the amendments to the Stable Token Act.
Director, hang on for just 1 second. Mr. Co-Chair.
And before we get to that, just so that it's clear, and I'm sure Senator Furphy understands that, but that's the primary issuance from the state directly to this, from the state to a financial institution. You'd be able to then have financial institutions, when we are fully implemented, transact with individuals. So a single token, a half a token, all of these things are plausible. It's just the nature of that primary interaction directly to somebody either acquiring or terminating tokens will be with a limited number of partners, and a lot of that is about security.
Director, please continue.
Thank you, Mr. Chairman. And I will just put a fine point on Senator Rothfuss's comment. What was just explained is called out in our business plan, and we specifically refer to it therein as licensed service providers and colloquially resellers of the stable token. With that said, I am happy to move on to some of the changes via the bill that's been proposed, and I think we can dive right on in.
Please do.
Excellent, thank you. So beginning on page 2, we are proposing changes to statute 719-106, section A, Romanet XLI, that the Wyoming Stable Token Commission, for the purposes of WS 40-31-103B Romanet 4 and 40-31-105C Romanet 7. Essentially what this says is the Wyoming Stable Token Commission will be able to receive the background checks that are performed on the director or the subject matter experts of the committee, which is the...
Mr. Co-Chair, or Director Young?
And sorry to interrupt, but just for those that are following along at home, we're looking at the Wyoming Stable Token Act amendments, which are in the materials 24 LSO 372, Working Draft 4, and we're looking at page 2 at this point.
Ms. Co-Chair, or sorry, Ms. Co-Chair, to tag on to that for some of the members, for the folks watching, it's also on page 5 of the director's report and some of the legislative updates that we've been coordinating on. So please go ahead.
Thank you, Mr. Chairman. I will also, just again, to put a bow on that, the statutes and policies in page 5 of the report is fairly analogous to what is here. It's not necessarily one-to-one, but I can have to call that out. So again, moving from where we were on page 2, now on page 3, in line 1, this again amends section 719-201A, Romanet 35. Persons applying to be a subject matter expert of the Wyoming Stable Token Commission or the director of the Wyoming Stable Token Commission, as required by WS 40-31-103B, Romanet 4, or 40-31-105C, Romanet 7. Again, in line with my comment from a moment ago, these in tandem move the language around background checks that are applicable to other agencies to the Stable Token Commission. Anyone who wants to be a subject matter expert or director will have to pass a background check, which will be received by the agency.
Director, hang on for just a sec. Mr. Co-Chairman?
I was just going to say, in a little background for that, for the committee, there was language in the original Stable Token Act that was put in by amendment, and the ad hoc language that was added didn't appropriately conform with our traditional statutory provisions for background checks to fully authorize those background checks. So this is a bit of cleanup that makes the background checks consistent with statute and also consistent with the practices and interests of the commission.
We don't want any felons. I think it's what you're trying, my co-chair is trying to say. I'm going to translate for my co-chair here. Sorry, Director, please go ahead.
And Senator Ellis is sensitive
to this. Undoubtedly. Director, please continue.
Thank you, Mr. Chairman. So moving on, now we are amending some of the wording within the powers of the commission section, which is 40-31-105. Again, these are overall looking to give our commission more leeway in how we're able to operate and what we're actually able to create. So the first change you'll see is we're striking out the wording overall number of on line 12, placing that on line 13 with types of Wyoming stable tokens to be issued. What we want this wording to do here is give ourselves from some future potentials of what we're actually going to create. Again, we are looking at a fiat-backed stable token at this point in time. My understanding is when this stable token bill actually began, it was purported to be gold-backed, right? So this is a way for us to potentially in the future issue stable tokens backed by any number of different assets such as gold, silver, real estate, so on and so forth. However, one step at a time, but this will allow us to perform that. Next change here later in line 13 is we're adding the wording, the supply characteristics for each type. What this is meant to intend is the Stable Token Commission will be able to define how many of each token would be minted. And I want to be very specific about the wording here. We are not going to say, much like may have happened in initial coin offerings along the way, we're not going to mint 1 billion stable tokens out of thin air and then look to sell those. This wording is essentially so that we can say, perhaps during our private beta, we want to have a limit of 100,000 Wyoming stable tokens out there as we start to onboard clients and institutions slowly and steadily before we go bigger. And then we can set the mechanics of how we issue stable tokens, how we redeem and subsequently burn stable tokens on the blockchain, and manage that process. I will pause there.
Committee members, any? Go ahead, Mr. Co-Chair, please.
Thanks, Mr. Chairman. And one other nuance that Commissioner Navas has raised is to make it very clear that there doesn't have to be a limit, which is part of this language. And if you have it limited, then it starts to look more like a security. You have to have the capacity to be unlimited. And this language was structured in such a way that supply characteristics can then incorporate the idea of an unlimited supply, which is just based on the number of, in our case, US dollars that we have matching the number of tokens. And at that point, it doesn't behave like a security, it behaves like a currency.
Mr. Co-Chair, for our friends at the SEC, just to keep it above board, exactly. We're on the record. Director, or Ms. Navas, did you want to, Mr. Representative Andrew, did you have let's first go to Ms. Navas first, and then we'll go to you.
Oh, no, thank you. I think Senator Rothfuss made this very clear. When you are dealing with the issuance of store value, which a fiat-backed stable token truly is, the limit is actually what we're receiving. So if you think when you walk into a retailer and you buy a gift card, right, there are several types offered, and you can select whichever one you want. These are all backed by dollars that you trade in exchange for that gift card, similar to what the issuance of a stable token is. So unlike other types of cryptocurrency that do not have a backing, for example, Bitcoin, right, that the price is determined by the market, when you are dealing with a fiat-backed stable token, to assess a number or a limit for issuance could give the perspective by different regulators that this is actually a different type of offering than a unit of store value, which this is going to be. So clarifying the act was to ensure that we remain within the spirit of the law as it was originally envisioned, while minimizing any potential misclassification of the token.
Thank you, Ms. Navas. Representative Andrew.
Thank you, Mr. Chairman. Going back to the part of the bill about opening it up to other types of stable tokens, such as a gold-backed stable token. I noticed that in the report there was a potential request of a very large budget allocation. And is any of that potential expense related to exploring issuing any of these other types of stable tokens?
Director, please.
Through the chair. Thank you, Representative Andrew. No, at this point in time, the budget does not contemplate us exploring these other types of tokens. I believe those would be secondary to a successful launch. We have to have one done right before we can do more than one.
Representative Andrew, part of it was also, and this was something that the co-chair and I really emphasized, was the chain agnostic, whether it's Cardano, Ethereum, all, blockchain, all these, or excuse me, Bitcoin, all these different types of chain options, was to make sure that we are not going to commit to any one particular one, but versus the idea of finding one that fits what we're aiming for and the objective versus trying to get boxed into any one particular technology. Representative Singh, go ahead.
Thank you, Mr. Chairman, Director. As of right now, is the state of Wyoming capable, well, for the plan for the stable token, is the state of Wyoming capable of delivering these tokens as a diplomatic gift to other bureaucratic entities?
Director, please, would you like to answer that?
Thank you, Mr. Chairman. Thank you, Representative Singh. I have not contemplated that at this point in time. I will mention that although it was not adopted formally by the commission at our October 19th meeting, I did put forth a very high-level V1 draft of a gift policy that would define how these tokens could be moved around to members of the government or of the Stable Token Commission, looking to limit that allocation. I think we want to be very careful about who we're giving away stable tokens to.
But it's a worthwhile idea, Representative Singh, Mr. Co-Chair.
Thanks. It seems to me, reflecting on the question, Representative Singh, that since this is a store value and it's, again, the token represents the underlying asset of a US dollar, anytime the state of Wyoming could give US dollars, which is pursuant to 16.6, not very often of the Constitution, you would be allowed to give a Wyoming stable token. But again, Wyoming Constitution is pretty limited on how often that could take place and how much value that could have. It would be pretty infrequent based on my expectation.
Yeah, there'd be public indebtedness concerns there. Director, please continue.
I believe we had Mr. Chairman, I believe we had a comment from Senator Furphy.
Senator Furphy, my apologies. Please go ahead.
Thank you, Mr. Chairman. Let me ask, this bill says the reserves will be invested in cash and government securities with a maturity of 1 year or less. What if we added U.S. government money market fund? So not taking any risk, but allowing some earnings on that cash just sitting there. Is that of value to you, Mr.?
Real quick, Director, let me jump in. Senator Furphy, I think that's what we're probably going to get to here in a little bit. So is it okay if we hold off on that one when we circle back and let them get through?
Okay.
That's okay? I mean, it's a good question. We want to make sure it's answered, but just do it sequentially. Director Paulo, please proceed.
Thank you, Mr. Chairman. In terms of the next edit, we are suggesting here on page 3, starting on line 20, adding the term financial service providers as a group that the STC can enter into contract, agreement, or arrangements and retention with. This, just to call out specifically, the term financial institution is defined in the Act in 40-31-102A Romanet 4. Financial institution means any entity approved by the commission to act as a manager or otherwise to manage, operate, and maintain Wyoming stable tokens. And we like to avail ourselves of a bit broader of a definition. If Commissioner Navas would like to explain that a little bit.
Ms. Navas, please go ahead.
Thank you, through the chair. When we were looking at, we're going to look at all the types of vendors that this token is going to need to be able to be successful. Financial institutions is a terminology that is usually addressing banks or any other type of licensed or charter institutions. We're going to have service providers, system integrators, KYC providers, an assortment of vendors that will be somehow classified into financial service providers more broadly. We want to make sure that we allowed for that contracting for the commission to ensure that we have the full roster of vendors that are needed to make this project successful.
Thank you, Ms. Navas. Director, please, go ahead.
Thank you, Mr. Chairman. Thank you, Commissioner Navas, for the context there. Flipping over to page 4 of the bill, again, starting on line 1, we are removing the word initially and adding the word publicly. So the sentence reads, before publicly issuing any fully reserved Wyoming stable tokens, the director shall provide a comprehensive report to select committee and joint minerals as well. So we've modified the wording here slightly to essentially react to the fact that there may be versions of a Wyoming stable token that are issued as a test token before we put out a fully reserved token on a public blockchain. So we wanted to confirm that rather than have the select committee receiving multiple reports from me that may not be as well aligned with the purpose of the wording here. We wanted to explicitly call out that This will be a comprehensive report delivered from me and my office to the Select Committee before anything that is fully reserved is launched.
Thank you, Director. Any questions on this part? Please proceed.
Thank you, Mr. Chairman. And then final change we have on the bottom of page 4, starting with line 19, in terms of essentially the investment vehicles we are able to avail ourselves of. We are adding cash on line 19. And also we're changing the term treasury bills to government securities with a maturity of 1 year or less. I would also invite Commissioner Naves and Commissioner Reville to include or expand upon any of these changes. I know there's been a lot of conversation around things like money market funds alongside the State Treasurer's Office. So I will leave the experts to quickly opine on that.
Ms. Naves?
Thank you. Through the chair, and I will, as Anthony pointed, invite Joel to add his background here as well. As the act currently reads, the full investment of the reserves is going to be in treasury bills. For liquidity purposes and to ensure prompt redemption of the token at the time that a holder requests redemption, to have all of these reserves invested in bills would delay the redemption process. It could potentially cause additional cost for the state. Having a balanced approach between liquidity and investments is recommended for fiat-backed stable tokens, and you see that in the market players that are in today, such as PayPal and Circle in the United States. So we wanted to make some changes to the bill to allow for that type of investment allocation, as well as ensure that the risk profile of that investment is not increasing in a way to potentially expose the state to any default. Having the ability to also address the U.S. government's liquidity, such as for any budget issues that the federal government may be facing. Management of reserves becomes even more important at that time to ensure that it doesn't fall below the 1-to-1 ratio. So this will enable the state treasurer and his team to manage this in a way that is prudent. We'll try to keep the 1-to-1 peg, which is the critical element for the token, and a redemption process that meets expectations of the token holders.
Thank you, Ms. Naves. Mr. Revelle, do you want to expand on that a little bit as well?
Thank you, Mr. Chairman. I'd like to address Senator Furphy's question from earlier, if I could please, here in this context, which is the question again was whether we would permit money market funds as an acceptable investment. The reason that we haven't expanded the language to include money market funds is because some of the investments that the funds themselves will make go beyond what we have envisioned as permissible investments. Money market funds are able to go out to 397 days of maturity. They're also able to include things like commercial paper, agency debt, etc. And I think our thought was to limit this to government securities that are within 1 year and not include those other asset classes that can be included in money market funds. In addition, you're also introducing some counterparty risk there with the fund complex or managers themselves that, again, just to err on the side of conservatism, we're limiting this to U.S. government securities and repurchase agreements and cash.
Senator Furphy, did that satisfy your question?
Thank you, Mr. Chairman. Yeah, I just wanted to have that addressed, and they've considered it, so thank you.
Mr. Chairman?
Mr. Co-Chair.
Yeah, in the discussion, honestly, the money market accounts realistically ended up being a higher risk than we wanted to start with, is what it came down to. And everyone here understands that that's generally contemplated to be an incredibly low-risk asset, and it was still a higher risk than we wanted to bring to the table for this, with it being first of its kind.
Director, please proceed.
Thank you, Mr. Chairman. I believe that is the end of the changes that we have in this bill.
So committee members, any question for the director, for any of the commission members? Seeing none, Mr. Co-Chair?
And just to stress a little clarification that as drafted for, we had treasury bills, and that's being changed to government securities with a maturity of 1 year or less. In a lot of ways, that's equivalent, but the treasury bills language would mean that the full maturity lifetime of the underlying asset, the treasury bill, would be 1 year or less. There is also tradability of longer-term government securities, so think arbitrarily a 10-year bond, but its maturity would have to be 1 year or less. So that's still a tradable instrument, but you have to be in the last year of the instrument for it to be allowed here, and there's a substantial market that would allow for that transaction, and you might do better with that instrument, which would be allowed. So while they might seem equivalent, they would be forbidden based on the language of the existing statute. And we would have to change that language to allow for you to purchase, again, for example, a 10-year bond that will mature 3 weeks from now. Would not be allowed, but with this changed language would then be allowed. And that nuance was certainly not something we talked through when we were drafting the legislation, but becomes an important one as you're contemplating dealing with United States treasuries.
Which is why we put maturity versus duration.
Correct. Yeah. You learn something new every day.
Every day.
Yeah.
Senator Furphy.
Thank you, Mr. Chairman. Maybe we can ask Mr. Rovell. The term government securities, that would include agency securities, which are of a higher risk than treasuries. So I'm curious what his thoughts are on that.
Mr. Rovell?
I do not believe we should include agency at this time. So if that needs to be more clearly specified, I think that's a good idea. I think that is a nuanced difference, and I think maybe you all or LSO might have a better view on whether government securities would include agency securities or not. But at this time, I do not think we should have them included.
Mr. Co-Chair, I think here's to the spirit of we're just trying to make sure we stay on these extremely low risk, ultra liquid assets. I think, Senator Furphy, it's to fulfill the promise of we are taking an extremely conservative approach to ensure that the money that we're received is that we're good for it, right? That we can turn right around and redeem it for the amount that we've told you that we will. Mr. Co-Chairman?
Thanks, Mr. Chairman. And we did talk a little bit about that and the fact that we wanted to exclude it. And in the conversation, I think it was probably left with a little bit of a question mark as to whether United States government securities, as we structured it, would or would not include agency securities. And we want to clear that up. So I think it is important that we
Mr. Chairman. Yeah, I was just thinking further, if I could, please. Yeah, I think just adding the word treasury might U.S. government or U.S. treasuries or U.S. government treasuries, I think would be the right term to use that would clarify not to include agencies. Excuse me for interrupting, Co-Chairman Rothfuss.
No worries. And Mr. Chairman, at that point, yeah, it could be cash in United States treasuries with a maturity of 1 year or less, I believe, is what Mr. Rovell is saying, which would achieve that.
Yeah, I think or Senator Furphy, go for it. When I say that, or say government securities excluding U.S. government agencies, or I think there's obviously multiple ways we could wordsmith it.
We can probably start with treasuries, but we can look into that a little bit more. One thing that is not currently included in this language, which needs to be discussed, though, is repurchase agreements. And the language does not currently include that. It doesn't include it in the existing language, and it doesn't include it in the proposed language. And repurchase agreements of treasuries of short term. So a lot of times repurchase agreements will be overnight repurchase agreements between banking institutions, typically, allows a higher level of liquidity and can meet our short-term needs similar to cash and transitioning quickly to cash, while having, as long as they're repurchase agreements related to treasuries, can reach that same level of security. And that's something that, since the first bill was passed, has been a request by many to provide that additional flexibility, and is something we probably need to include. And that could be through the addition of the language after the 1 year or less, and government security, or alternatively, United States Treasury repurchase agreements of not more than 30 days to contemplate.
Yes, Mr. Chairman.
Director, please.
Thank you. Just in the co-chair's comment, it is my understanding that the term government securities would be inclusive of repurchase and reverse repurchase agreements, based on my discussions with the Treasurer's Office.
Is anybody from the Treasurer's Office? Doesn't look like it. Confirmation. Mr. Ravel, could you maybe expand?
Yeah,
on just your
I'll do
exposure?
my best. Thank you, Mr. Chairman. So a repurchase agreement, and we'd probably want to include a reverse repurchase agreement here as well, but a repurchase agreement is typically a tri-party agreement whereby there are U.S. government treasuries pledged and backing typically an overnight, but it can be a little bit longer agreement between financial institutions. So the credit risk that you're taking on is still a government treasury credit risk, because you have those treasuries are pledged as part of that agreement. But there are certain instances where we would want to give the Treasurer's Office the ability to use a repurchase agreement as opposed to treasuries directly. And I'll maybe just quickly highlight two important use cases. The first is that would enable the Treasurer's Office to earn yield on cash in a very short term. So without that ability, it would be very hard for the Treasurer's Office to be earning yield on cash. With repurchase agreements on kind of an overnight basis, then you can be kind of sweeping into repos and earning yield, which would be important for revenue considerations for the state. And then the second use case, which used to be rare but is increasingly not so rare, is if the government is going into a shutdown because of there's been no budget bill passed, and there is a risk that the U.S. government would not be able to fulfill its interest obligation on its treasuries, whereas a repo would be a better credit risk, or at least a better risk in terms of receiving the payment due in those instances. So we'd want to give the Treasurer's Office the ability to shift towards repos if a government shutdown was imminent.
And so, Mr. Ravel, just to expand on that, because I was under the impression that the U.S. government security could include repos where treasury bills, notes, et cetera, are the pledged collateral in the asset. Is that correct? They fall within that definition? Yeah. Okay.
Yeah.
So with the government securities language, making it clears up the allowance of repurchase agreements and reverse repurchase agreements, but does seem to imply that it opens it up to agency securities as opposed to just treasury related securities. So it seems like we need a term of art there that appropriately captures treasuries and their associated repurchase agreements and reverse repurchase agreements, again, with maturity of 1 year or less, but not associated with agency securities. And Mr. Reville mentioned the idea of putting federal or
Treasury.
If it were United States Treasury securities, does that include repurchase agreements and reverse repurchase agreements, or United States Treasury government securities? Is that sufficient? This is something we can get with the Treasurer's Office and wordsmith a little bit later, but it would be nice to try and get this draft, if we pass it today, to be in good shape. I see Mr. Pope has.
Mr. Revelle, let's just let Mr. Pope in real quick.
Of course.
Thank you, Mr. Chairman. Why can't we just exclude agency securities? Just everything except government securities, with the exception of agency.
Yeah, Mr. Pope, and that was kind of the one that I had mentioned earlier. We said, with the exception of those agency securities. I think that's kind of what we're trying to hash through now. Mr. Revelle, you looked like you wanted to say something.
Thank you, Mr. Chairman. Yeah, I was just going back to Co-Chairman Rothfuss's question. I think it is a question for the committee as to whether we want to most clearly define this for purposes of the Treasurer's Office, or whether we want to define this where it is most easy for legislative purposes. I think that we're being a little bit vague with the term government securities. I think optimally the language should read, for purposes of clarity to the Treasurer's Office, it should read U.S. Treasuries and repurchase agreements. If that opens up a kind of ball of wax that you don't want to get into with the legislative process, then I think one could consider securities broadly to include repurchase agreements, but that's a little bit vague, technically speaking.
I guess Mr. Co-Chairman, my thought was, sounds like half the problem would be, you said, the thing that I mentioned and Mr. Pope did, where if we just, with the exception of agency securities, but does that fully address your point of are they explicitly included in the definition, or repos explicitly included in the definition? Mr. Co-Chairman?
Well, I do like the idea, Mr. Co-Chairman, of having it say United States Treasuries specifically, and then with a maturity of 1 year or less, and their repurchase agreements, or associated repurchase agreements, or their associated repurchase agreements, something along those lines, so that it's clear that we're talking about U.S. Treasury bills, and not, U.S. Treasuries.
Mm-hmm.
And we can noodle on that a little bit more. The one concern I have with excluding agency securities, having the exclusion, is I guess I'm not entirely sure if there's something else we're missing on the exclusion list that needs to be there. And I like the idea of being explicit to United States Treasuries as being the category that's allowable. That gives a lot more comfort, I think, to the surety that's there, and then allowing for repurchase agreements. So we can noodle on that a little bit more. I don't know if anybody else has any questions or ideas.
Mr. Chairman, I want to agree with Co-Chairman Rothfuss that it is securities is a bit vague, and it's not clear that there wouldn't be something else besides agencies. And then conversely, I think it's it's not clear that that does include repurchase agreements either. So I think that the direction that Co-Chairman Rothfuss has just headed with U.S. Treasuries or repurchase agreements backed by U.S. Treasuries is the right direction to go for purposes of market clarity.
Yeah, Mr. Revelle, that was exactly what I was going to tag on as well, where it was, so long as we stipulate that those repurchase agreements are only where are collateralized by Treasury. So I think in the context of the build out means we could just simply reinsert the stricken language, the treasuries, and keep bills struck. For at least that first part. Mr. Co-Chair?
Yeah, Mr. Chairman, so yeah, if it would cash in United States treasuries with a maturity of 1 year or less,
To include.
we could have an or an and there either way, U.S. Treasury or repurchase agreements backed by United States treasuries. And then with the repurchase agreements, the concept in the repurchase agreement is not the length of the treasury, but the length of the contract for the repurchase agreement. And most of them will be overnight in the discussion. We could probably do it as a week. We could probably do it as a month. We wouldn't want to go longer than a month on the repurchase agreement. We'd want them to be short-term repurchase agreements.
Correct. I think, yeah. Yeah, we can
Yes.
work something. Mr.
Mr.
Revelle, please go
Chairman,
ahead.
yeah, I just want to thank you, Mr. Chairman. I just want to emphasize something that Co-Chairman Rothfuss hit on, which is that in the language, we want to make sure that we don't tie the limit of 1 year or less maturity on the Treasury to the treasuries that could be backing the repurchase agreement. So there are two different maturities to contemplate here when you're talking about a repurchase agreement. There is the maturity of the agreement itself, and then there is the maturity of the treasuries that are pledged behind that agreement. We don't want to limit the latter to 365 days. We do want to limit the agreement, and I would actually say to 30 days or less. And I don't know if we need to be doing all this in legislation or not, but just to clarify that.
Mr. Chairman,
Co-Chairman.
on that, would maturity still be the appropriate language for that? So would it be a repurchase agreement backed, and whether backed is correct, but backed by United States treasuries? And then that repurchase agreement, should the maturity of it be 30 days or less? Is that the concept? So still a maturity is the appropriate term there to govern the contract length of the repurchase agreement. Okay.
Correct. Yes, that should be modifying the repurchase agreement, not the underlying treasury pledge.
Mr. Co-Chair, my thought was maybe we can, in the meantime, sort of wordsmithing an amendment, and we can bring that back when we go to work the bill.
Yeah. We can work the bill after lunch.
Yeah, we're going to be running up here quite shortly.
That'll give us some time to think about the language.
Yeah. So, Director Paul, was there any further discussion that you wanted to have before we open it up to other folks?
Thank you, Mr. Chairman. I appreciate all the comments made. I think this is important to get right and convey that we are looking to create a low-risk instrument while still availing ourselves of different vehicles with which we can actually move forward. I might suggest going into this process, my understanding with the act would be fairly broad, and perhaps the specifics of how each one of these instruments would be used by the Stable Token Commission could be done by a policy created on our side through our rulemaking authority.
Correct.
And I will mention one more thing. If we are going to wordsmith the language here, I would probably look to call out reverse repos specifically, rather than have it be an implicit statement within repurchase.
Mr. Co-Chair?
Thanks, Mr. Chairman. That's something that maybe we can get something definitive on. Is a repurchase agreement the same as a reverse repurchase agreement from a statutory standpoint? It would be nice if we didn't have to explain reverse repurchase agreements in addition to repurchase agreements, because one encompasses the other. But if they're two different things, then we'll need to find a way to accommodate that. So
Mr. Ravel, could you maybe touch on that?
Again, I think that's a question for how you would like to legislate this. One is borrowing and one is lending. Yeah, you're on the other side of a repurchase agreement. So I think an argument could be made that, or wording could be picked that it's all a repurchase agreement. It just depends on whether you're the borrower or the lender.
Mr. Coach, how do you think we could? It wouldn't take much to really get in the weeds on that
That's what I'm worried
specific
about,
one,
yeah.
which is a little concerned about making sure the wording is just right, that authorizes the treasurer's office to do what we want it to do. Director Paulo, was there anything else you want to expand on before or Ms. Naves?
Nothing from my side. Thank you, Mr. Chairman.
So let's go ahead. It's 11:52 right now. Obviously, we're not going to finish this before lunch, so maybe let's just get one or two public comment in, and then we'll break, come back in and finish it off after lunch. So we're going to go ahead and open up to public comment. First, we're going to go in the room. Does anybody want to come up and testify on this bill? Obviously, we know who you are, but you know the protocol.
My name is Scott Moore. I'm one of the organizers of the American Crypto Fed DAO. And thank you for the opportunity to make public comment on this. We do have a couple of public comments. Troy, did you want to? Okay. My comments are really related to one. I was a bit surprised to see the $8 to $12 million request for additional funding, especially at the same time that I saw that IOHK was offering to build a version of the token for $1. My concern is going back to the legislature and asking for additional funding at a time when it's IOHK is offering to build for $1, and we had also suggested a parallel project involving the University of Wyoming to build out the token. So that's a concern.
Committee, any questions for Mr. Miller? Seeing none? Please, for committee processes, state your name and the organization on which you are representing.
Yes, good morning. And my name is Troy Carruthers. I'm representing American Crypto Fed. And first of all, thank you, Chairman Western and Rothfuss, as well as the rest of the committee. One thing I actually have is a question first. It's just for clarification, is if it is the committee's intent to create a state-owned bank to help move the WST forward. Part of the reason I asked the question is I've read different conflicting items on this from Business Plan 1 to Business Plan 3, as well as even just some responses that have been on the public site here more recently. So I asked that question because it actually pertains as well to the letter that the committee put out here recently with the goal to achieve a widespread release as quickly as is prudent. So again, part of the reason for the question is if the committee's intention is to create a state-owned bank, I'm afraid it will have a very difficult time trying to reach its own goal of being able to have that widespread release.
Committee members, any questions for Mr. Carruthers? I will certainly say it is certainly not the intention of this committee to create a bank of any kind. So, well, that answers your question, Mr. Co-Chair.
Yeah, Mr. Chairman, I'd say that we've heard discussion about that possibility. I don't think that has to be a possibility. Some of the discussion about that possibility comes through the idea of federal regulatory structure and what may or may not be required in discussions associated with stable tokens and stable coins. That's sort of where I've heard that circulating. As yet, I don't believe there's anything that compels us or requires us to create a bank to achieve the interests of this legislation. So that isn't the intent. That would be an interesting barrier for us to work with. And we have not heard any requests associated with that from the commission either, telling us that we need to figure out how to create a bank. So unless the commission, and in their role of creating the stable token and carrying out the legislation, comes back to us, that would have probably been a pretty significant request in this bill. And I think they would have told us if they wanted us to make a bank.
I think we would have noticed that.
I think so. So I don't see creating a new bank. Again, I see the state working with financial institutions and financial service providers as the general theme that we've seen put forward.
Excellent, thank you.
Committee members, any further questions for Mr. Crothers? Thank you very much for your time.
Can I?
Please, yeah, if you have something else.
One more.
Please go ahead.
Piece, thank you. And it's in relation to the conversation that took place a minute ago in relation to liquidity. And I know that we're looking first, or your intention first is to have institutional acceptance, and then later acceptance at retailers, merchants, the like. As I read through the document from Director Apollo, there was a statement or a recommendation on page 5 in relation to T+2 on transactions. So that's referencing the settlement of transactions. I bring this up because having represented merchants for 25 plus years in the payment space, there's nothing more important to a merchant than being able to get their proceeds today from that transaction. So I would encourage the committee, as you're looking at different aspects of this as well, to, if you want wide acceptance from retailers going forward, that the retailers are going to want that real-time settlement. So if that is not possible, then the retailers are going to need something additional, right, to be able to make that, or to want to make that exception. Okay.
Any committee members, real quick, any questions? Mr. Co-Chair?
Thank you. On that point, and again, I think there's a lot of work still ahead with the RFI to start developing how that structure is going to look. But if there are financial institutions that are directly engaged as the licensed service providers with the state of Wyoming, it seems to me that having an account with one of those institutions gets you effectively instantaneous settlement, or relative to how quickly they're capable of settling out on their large-scale transactions, and that even a merchant could potentially, at some point in the future, become one of those licensed service providers if they were a sufficiently large entity where they were capable of having large throughput transactions to have direct engagement. I don't think anything is precluding that at this point. That's something for us to contemplate, though, and in the discussion, is to make sure that we have that flexibility. And again, I don't know that that'll be the first day flexibility, but I understand that intent of being able to have those direct transactions if you're having enough throughput that it significantly matters to you to have quick transactions, overnight turnovers, which is the interest there, and to be able to accommodate that at an institutional level. I see the value of that. Appreciate that testimony.
Mr. Co-Chair, I certainly think point's well taken, right? People they do a deal, they want it to happen now. And I think that's something we're fully aware of, and we acknowledge that that's going to be a big component of doing this successfully. Right now, you're seeing the airplane being built while it's being flown to a certain extent. So yeah, we have to take that in consideration. But absolutely, we understand that when you're dealing with serious actors, they want it to be done in a serious way, and that part of that means being settled immediately. So absolutely. Excellent. Is there any further questions? Any further testimony? Mr. Crothers, please go ahead. We'll give you about a couple more minutes, and then we're going to break it off and reconvene. Please go ahead. So we'll let you be the last one to testify before we break for lunch. Please come forward.
Thank you, Chairman. My name is Shangwon Zhou, the organizer of American Crypto Fed. And I'm talking about the stable token legislative report provided by Director Apollo at page 4. At that page, it said Wyoming stable token will be quite similar to settlement tokens already in the market. So that means Wyoming stable token will have no competitive advantages. So PayPal's and the USDC, they are all, it's the market. And if they are similar, so the merchant will just use what are already there. And we don't believe the current business plan just to try to produce what are already in the market can be any attractive to the merchant. So we hope the Wyoming stable token can involve community banks, speedy banks, take advantage of what already have in Wyoming crypto law and create something unique, which the market does not have. Thank you.
Committee members, any questions for Mr. Zhou? Did I pronounce that correctly, Mr. Zhou? Seeing no questions, thank you very much for your testimony. We appreciate it. We're going to go ahead and break for lunch. We will resume public testimony, and Mr. Murphy, you can be the first one up after lunch. Oh, you have. Go ahead, Mr. Murphy.
Thank you, Mr. Chairman. I will be brief, but also thorough with my comments. My name is Sean Murphy. I am here representing myself, as well as the interests of family, friends, and other conservatives in Wyoming that really want me to give these comments today. And I want to start by saying I hope that I'm not interrupted with what I'm about to say. Some of these comments are not, they're not completely positive, but they're very genuine, and I just ask that I be allowed to share these 3 minutes of comments. So with that said, I first came to this committee 2 years ago to the date, give or take a few days, and I came talking about the largest blockchain deal in Wyoming history. And in that process, I got involved with the Wyoming stable token. And when I came, one of the senators on this committee said, one of Wyoming's sons have returned. And that sounded really nice. I was like, I've been using the term reverse brain drain. So I was like, one of Wyoming's sons, that's pretty great. And as I thought about that, I realized many of you are Wyoming's sons and daughters too. It's a very nice phrase that she has. And I thought about that. Is it that I was born and raised here? Is that what makes us a Wyoming son or daughter? Maybe. Is it that we've been here for generations? Maybe, but I think it's that we have shared values. And I think that there are certain values as Wyomingites that we think are important and that we stand for. Equality, freedom, liberty. And then there's important things that I think we stand against. And this is one example before I get into about the Wyoming stable token and the largest blockchain deal in Wyoming history is I stand very clearly against any government, political party that is killing women, children, and elderly. I mean, that's something we have to stand against, right? I'm for peace, but I'm not against war, but killing of women, children, and elderly, this is something I'm against. So at a lesser level, I'm also against reckless government spending. Okay, that's on the table. And Where that goes with Wyoming Stable Token is this. In full disclosure, I applied to be the executive director. I want to congratulate Mr. Apollo on being selected, and I honor and appreciate the committee's selection of Mr. Apollo. But there's a major conflict of interest that is not being discussed. One of the commission board members, Mr. Brian Wallace, he is a board member of the Kansas City Federal Reserve, right? Okay, so independence, and an auditor will tell you this, independence is defined by fact and appearance, right? So now we have a member of the Wyoming Stable Token Commission who is on the board of the Kansas City Federal Reserve Board. And Senator Rothfuss, you know I supported all the way along this legislation, the Wyoming Stable Token, based on the fact that this was going to be a hedge against a US CBDC. That was the entire premise, that we were going to create something that wasn't a CBDC, that provided people, Wyomingites, institutions, a financially free, liberty-focused path to transact. And now what? Now we hear today, it's an $8 to $12 million budget request. And there's no talk that there's going to be any gold backing, there would be any Bitcoin backing, any true stores of value. The US dollar is not a store of value. That is a depreciating asset. All right, and anybody who understands how the Federal Reserve works, it's not federal and it's not a reserve. Okay, it's a private central bank for this country. So at a very high level, and I've totally drifted off what I wrote down here, but at the very high level, what I observe happening here is the Wyoming Stable Token has been hijacked. It's been hijacked by the very institutional banking interests that we developed it to protect and compete against. And I have clearly defined and told all of you that I know where the conflict of interest it is. And we saw one of the members of this committee, there was a conflict of interest with the Federal Reserve, and she's no longer here. And that was a good thing. And that made a lot of sense, but that's happening with the Wyoming Stable Token. So I have a request. My request is that any members of the Stable Token Commission step down if they have conflict of interest with the Federal Reserve or any institutions, banking institutions. Okay, so that's my request, and I hope that that's honored. Second item, and the second request, is involving the largest blockchain deal in Wyoming history. And I'm talking about the BCIS Power Agreement, $175 million deal. I was hired to work for Bison Blockchain. We won the RFP. In this process, I want to be very clear, I have tremendous respect for Mr. Kaufman and the attorneys at his firm. In the process, and what we've come to learn from the New York Times article that was published several weeks ago, is that the company that Mr. Kaufman and his firm represented, YZY Capital, this is run by a CCP member. Okay, we know that. I have his name here, Yuan Kian. Mr. Kaufman could tell us his anglicized name. That's a conflict of interest, everyone. This is an enemy of the United States and the enemy of a state, CCP. You could say maybe not in physical sense in terms of arms, but absolutely in ideological sense in terms of our values, representing a CCP member. And more, since this article was published by the New York Times, we've been contacted by other, let's call them agencies and research institutions, that have said that one of the companies that Hathaway and Coons represents is also controlled and directed by another CCP member. And we are getting to the bottom of this. And I want to let all of you know that we're going to share more information with you. But my request today is for you specifically, Mr. Kaufman, that you either step down from this committee and continue representing this CCP through your firm, or your firm does that, or stay on this committee and stop representing through your firm CCP-backed entities. Again, conflict of interest are defined by independence of fact and appearance. And this thing we talk about, the Wyoming brand, the appearance of this, let alone the actual security risks, we are on a big scale here in terms of threat and risk vectors. So I've shared these two requests, one involving the Wyoming Stable Token Commission and the conflict of interest here, and then also considering the BCIS agreement, the largest deal in Wyoming blockchain history. Okay, 75 megawatts, and they're looking to expand another 65 megawatts. There is nothing close to that other than Crypto Night, which is a whole nother conversation. So those are my two requests, and thank you for letting me share these comments.
Thank you, Mr. Murphy. Committee members? Any comments or responses? Seeing none? Thank you for your-
Please, Senator, you're my representative.
Mr. Murphy, through the chair.
Mr. Chairman, apologies. Mr. Chairman, if Senator Ellis, my representative.
Mr. Chairman, I don't
Senator
have any
Ellis.
comments other than to say, I think we've just really veered off course. You know, I understand these are public forums, but it's also, you know, one thing to start a conversation about the private workings of law firm where there's confidentiality requirements for attorneys, and I just think we've really veered off course and should probably end this discussion right now, unless anyone feels differently, but.
Mr. Murphy, thank you very much for your testimony. We're going to go ahead and break for lunch. It is now 12:12. We will come back at 1:30? 1:30. At 1:30, thank you. We are adjourned for lunch.